Good morning, everyone. Good morning, everyone. Please have your seats so that we can start the session as promptly as scheduled.
vehicle is speeding, might be possible 422. Adam 99 for dispatch outbound on E12. You got more information on the vehicle. Vehicle is blue, McLaren, late model. 10-4, I'm clear.
A warm good morning to all. I request respected Krishnamurthy Mishra, Director, Madhya Pradesh State Judicial Academy, to kindly escort the dignitaries to the dais, please. Good morning and a very warm welcome to the second technical session on enforcement mechanisms, challenges and best practices. In this session, we shall delve upon jurisdictional issues, judicial enforcement mechanisms, injunctions overview, brief overview of criminal remedies and arbitrability of IP disputes. This subject reminds us with the words of Honorable Supreme Court of India enunciated in the case of State of Punjab versus Devinder Pal Singh Bhulla. The majesty of law is not in the power it wields, but in the protection it offers to every citizen. We are honored to have this session chaired by Honorable Chief Justice Subodha Abhyankar, and the session shall be co-chaired by Honorable Chief Justice Pranay Verma, Honorable Chief Justice Prakash Chandra Gupta, Honorable Chief Justice Sanjeev S. Kalgaonkar, Honorable Chief Justice Avnindra Kumar Singh, and Honorable Chief Justice Binod Kumar Dwivedi. Another privilege for us is to have occasion to hear a distinguished resource person for the session, Honorable Chief Justice Sanjeev Sachdeva, a dynamic leader, innovative individual, and Honorable Judge of our own High Court. We also have amongst us Mr. Gaurav Miglani, Managing Partner of Worldwide Intellect. As we move forward, it is my great honor to commence this session by felicitating our esteemed guest. Firstly, I request Shri Manoj Kumar Srivastava, Registrar General, High Court of Madhya Pradesh, to graciously extend a cordial welcome to Honorable Shri Justice Sanjeev Sachdeva. Thank you, sir. Next, I request Shri Rajiv Apte, Principal District and Sessions Judge Rajgarh, to kindly extend a heartfelt welcome to Honorable Shri Justice Subodh Abhyankar. Thank you, sir. I would now like to request Shri Sanjeev Kumar Agarwal, Principal District and Sessions Judge Dhar, to graciously extend a cordial welcome to Honorable Shri Justice Pranay Verma. Thank you, sir. I would now like to request Shri Vivek Saxena, District and Additional Sessions Judge Bhopal, to graciously extend a cordial welcome to Honorable Shri Justice Prakash Chandra Gupta. Thank you, sir. Here I would like to request Shri Prakash Chandra Mishra, District and Additional Sessions Judge Indore, to graciously extend a cordial welcome to Honorable Shri Justice Sanjeev S. Kalgaonkar. Thank you, sir. Following that, I would now like to request Shri Jayant Sharma, Registrar Inspection and Litigation, to graciously extend a cordial welcome to Honorable Shri Justice Avnendra Kumar Singh. Thank you, sir. At this moment, I request Shri Samresh Singh, Registrar Information and Technology, to graciously extend a cordial welcome to Honorable Shri Justice Binod Kumar Dwivedi. Thank you, sir. Lastly, I request Dr. Dharmendra Kumar Tada, Faculty Member, Madhya Pradesh State Judicial Academy, to warmly welcome Mr. Gaurav Miglani. I request Shri Krishnamurthy Mishra, Director, Madhya Pradesh State Judicial Academy, to warmly welcome Mr. Gaurav Miglani to this esteemed gathering. Thank you, sir. I now humbly invite Honorable Chairperson, Honorable Shri Justice Subodh Kumar Abhyankar, to kindly open the session and set the stage for the deliberation.
Honorable Justice Sanjeev Sachdeva and all the dignitaries present on the dais and off the dais, a very good morning to you all. Yesterday we heard about the basics and fundamentals of IPR, and before we commence our second session, I would just like to inform you, sir, about a lawyer's perspective so far as this part of the country is concerned. Not too long ago, when I was in practice prior to 2016, whenever an IPR matter would come up before a lawyer, he would search for a lawyer who might be knowing that who is the person who might be knowing the IPR law. So this was the situation, and it was equally with the judges also, as and when a matter would come up before a judge, he would not see the act, he would see whether the act is available with him or not. So this was the situation, but the situation has changed drastically, and I believe, looking to the fact that India is on a is galloping on a progressive path, future, and Indore being the cleanest and the most developing city in India, I believe that this is the right time when Honorable Justice Sachdeva Sahib has taken initiative and has brought this program to Indore, where we all would be going to enriched by his expertise. You must have seen the trailer, I believe, that Justice Sachdeva just played now. So without further ado, I switch over to Mr. Sachdeva.
Thank you, Subodh. There are two things which I would like to respond. What you just said gave me an idea. I think we need to then hold a similar conference for the lawyers, which we should do very soon. And secondly, when you go and watch a movie, I don't know, I have not seen a movie in a hall. What happens is when you go for a movie, you see those trailers, and trailers have got nothing to do with the movie. So this trailer that you saw has got nothing to do with the presentation.
Thank you, my lord. Before we proceed to the most awaited event of hearing our learned resource persons, allow me to give their brief introduction. Our first speaker for this session is Honorable Shri Justice Sanjeev Sachdeva, an eminent jurist. Sir. If the dais allows, I'll introduce both resource persons first. Our first speaker for this session is Honorable Shri Justice Sanjeev Sachdeva, an eminent jurist and a beacon of knowledge in the realm of intellectual property law. My lord's distinguished careers, which span decades of unparalleled legal brilliance, is a testament to his unwavering commitment to the justice and legal scholarship. Born in the vibrant city of Delhi, Honorable Shri Justice Sanjeev Sachdeva pursued his education at some of the country's most prestigious institutions, including the esteemed Sri Ram College of Commerce and the Campus Law Center at Delhi University. My lord has earned numerous accolades, including a prestigious British Council scholarship, which enabled him to represent India at the Commonwealth Young Lawyers course. His impressive legal journey includes being designated as a senior advocate by the Delhi High Court and serving as standing counsel for the Bar Council of India, having practiced extensively in the Supreme Court of India and the Delhi High Court. His lordship was elevated to the bench in the year 2000. So, my lord has graced this esteemed Madhya Pradesh High Court from May 2024. Our second distinguished speaker is Mr. Gaurav Miglani, Managing Partner at Worldwide Intellect, a leading intellectual property biotech firm. Mr. Miglani's exemplary career has seen him handle complex IT litigations, and he is a represented figure both nationally and internationally in the IP domain. Here, it is my honor to call upon Mr. Gaurav Miglani, Managing Partner at Worldwide Intellect, to kindly share his invaluable expertise and enrich us with his profound knowledge. Sir.
Thank you so much, ma'am. Very good morning to all the honorable judges on and off the dais and all the distinguished guests present here today. It's a pleasure and honor to be here and to be speaking in front of such a esteemed audience and to be able to participate in this colloquium. I'm truly grateful to my Lord's Justice Sachdeva for giving us this platform and this opportunity to interact with you today. And thank you very much, sir, for allowing me to share this space with you and present along with you. So in this session, we thought we are going to discuss some of the foundational jurisdictional issues that are somewhat peculiar to intellectual property statutes that are not to be found in other legislations, and we will highlight some of those. We also wanted to talk about some of the criminal and civil enforcement remedies that are available in law, briefly touching upon the injunctions and what are some of the challenges. While I will talk more on the criminal enforcement issues very briefly and the challenges therein. My Lord's Justice Sachdeva will do rest of the infringement, common law, injunctions and all. And then we want to very briefly talk about how does arbitration sort of fits in this whole scheme of redressal of intellectual property disputes and whether IPR disputes are in fact even arbitrable. So if you'll see, I put in 4 different IP statutes here, under which most of the litigation would come before commercial courts or the original site high courts. Under the Trademarks Act, if you want to file any suit for infringement of a registered trademark, or under the Patents Act, a suit for infringement of patent, likewise under the Copyrights Act, the infringement of copyright, and under the Designs Act for the piracy of registered design, the statute provides that no suit will lie in a court which is inferior to a district court having jurisdiction. So that is irrespective of the value of the suit. A suit cannot go below the level of the district court. But if you see, there are 2 peculiar features in the Patents and the Designs Act, which is that where a counterclaim, in case of Patents Act, in case there is a counterclaim filed by the defendant in the suit saying the patent itself is invalid and is liable to be revoked for any of the grounds that are provided in the statute, saying that even if you say that I have identically copied the plaintiff's invention, still I cannot be held liable for infringement because the patent itself is invalid and is liable to be revoked, and here is my counterclaim for revocation, then the suit shall be transferred to the High Court for decision. So in this scenario, the commercial court, the district court that originally had jurisdiction to deal with a suit for patent infringement, loses that subject matter jurisdiction and the suit has to be transferred to the High Court. Under the Designs Act, there is no provision for a defendant to file a counterclaim for cancellation of the design. That power is before the controller of designs. But what the defendant can do is that any of the grounds on which the design can be cancelled under the Act. So a defendant can come and say that the design was invalidly granted because it was not new and original on the date when you sought registration, or it is liable to be cancelled for other reasons that are provided in the Act. He can avail any of these as defenses. And the moment a defense as to invalidity of the design is taken in the written statement, then also a suit for piracy of registered design has to be transferred to the High Court for decision, and the commercial court, district court, loses jurisdiction to deal with it. But the scheme under the Trademarks Act is a little different. Here, the court does not lose jurisdiction, but what the court has to do is to stay the suit until the issue of validity is decided. So I just wanted to highlight how it flows. And the scheme provided under Section 124 is that if a suit for infringement of a registered trademark is filed, there can be 2 scenarios. Either the defendant will come and say the plaintiff's registration of mark is invalid, it is wrongly granted, or maybe it was rightly granted in the first instance, but it now wrongly remains on the register. Or the plaintiff can plead invalidity of defendant's registration. There could also be a scenario where the defendant himself may be a registered proprietor of the trademark, and the plaintiff comes and says, yes, while the defendant has obtained this registration, but this registration is wrong, it was wrongly granted, maybe he misled the registrar, he played a fraud on the registrar, or for various other reasons, the registration is bad in law. In either of these 2 situations, the first question that the court asks is, to either the plaintiff or the defendant, is there any rectification proceeding pending? Have you filed? You are coming before me and challenging and saying that this registration is wrong, it's bad in law, it's liable to be rectified. So have you already filed any proceeding for rectification of the mark? If the answer is yes, the court will stay the suit and allow the issue of validity to be decided. Now, this rectification proceeding could be pending either before the registrar of trademark or the High Court. Both have concurrent jurisdiction to decide on the validity of the mark. But if the rectification proceeding is not pending, what the court will do is the court will put a question and say, please satisfy me that this plea that you are taking is not a frivolous plea, and the validity of the mark, invalidity of the mark is even prima facie tenable. So if the plea is prima facie tenable, and the court comes to this prima facie conclusion, the court will then raise an issue, frame an issue as to invalidity, adjourn the suit for a period of 3 months, and give that plaintiff or the defendant, whoever has pleaded invalidity, give him 3 months to apply for rectification, in which case the rectification petition will go only to the High Court and not before the registrar. And if the rectification has been filed by that party within the period provided, the court is going to stay the suit. So the proceedings are going to be stayed until the issue of validity is decided. So what we have seen is that the Honorable High Courts have jurisdictions in 3 scenarios under the various IP statutes. One, as I said, where they will entertain suits that have been transferred from the district courts. So it is even for the courts like Madhya Pradesh that do not have original civil jurisdiction. But if a suit is transferred under the Patents Act or the Designs Act because a plea of invalidity was taken either by way of counterclaim in patents or as a defense in the written statement in case of designs, the suit gets transferred and the High Court gets the jurisdiction to deal with it. Then there are appeals against the orders of the controllers of patents and designs and registrar of trademarks that are provided under various statutes. Those appeals come to the High Court, and High Court is the only statutory body to hear that appeal. And then there are rectification, cancellations, and revocation petitions, as I said. So where the trademark or the copyright or the patent is a challenge on the ground that the right itself, the underlying right itself is invalid, then those petitions, the High Court is empowered to entertain under the various IP statutes. But the question then arises that which High Court gets these jurisdiction? Now, if we look at it from the perspective of the trademarks registry, the territoriality, the jurisdiction is territorially divided between 5 different offices. So we have offices in Delhi, Mumbai, Kolkata, Chennai, and Ahmedabad. So for instance, so far as the state of Madhya Pradesh is concerned, the jurisdiction vests with the Mumbai office. So if, let's say, a person who has a principal place of business in Mumbai, in Indore, he wants to file a trademark application, the application will be processed by the Bombay Trademark Registry, and it will be, if any order is passed by the Registrar of Trademarks Mumbai, then the appeal against that order will go to the Bombay High Court. Now, the question arises that does this apply only to appeals, or does this also apply to the original petitions, which are rectifications or cancellations? So consider a scenario where a suit is filed in commercial court Indore, basis that the call of action has arisen in Indore. The plaintiff, on the other hand, is not from Indore. He's maybe from another state, let's say called Chennai, and the relevant registration, therefore, was also granted by the Chennai Trademark Office. But in the suit proceedings before the Indore Commercial Court, invalidity of plaintiff's registration is pleaded, and Section 124 scheme kicks in. So the question is, would the Indore Commercial Court stay the suit and ask him to file a rectification in Chennai, or can the rectification also lie before the Madhya Pradesh High Court? Now, there is a recent judgment of the Delhi High Court on this point of law, where the single judge came to the conclusion that the rectification proceedings, petitions under the Trademarks Act, are not only maintainable in those high courts like Mumbai or Chennai that granted the registration, but also before any court within whose jurisdiction the dynamic effect of that registration is felt. Now, what this dynamic effect means is, and basically the reliance was placed on the case of Girdhari Lal Gupta that was decided way back in 1977 by the Delhi High Court, where the court said that registration that is granted by an office is situated at a certain place, but the impact of that registration travels beyond that place. So it is just because the registration has been granted by the Chennai Trademark Registry does not mean that the registration is valid only in that state. The registration is for the whole of India, and the effect of that registration may be felt in different jurisdictions. So the court said that the High Court that has jurisdiction this was a designs case, and the court said that, look, it gives jurisdiction to the High Courts, not only where the design is registered, but where it causes injury to the commercial interests of the petitioner. So in this case, let's say the suit was filed in Indore, and the plaintiff is able to challenge that because of the call of action has arisen in Indore, the plaintiff is able to file a suit in Indore. Now the defendant comes in and says that if the plaintiff gets a right to challenge my use in Indore because some injury has been caused in Indore, then I am also being injured by the plaintiff's registration in the city of Indore. So therefore, there is a dynamic effect of that registration that is being felt within the city of Indore, and therefore the Indore bench of the Madhya Pradesh High Court should have the jurisdiction, which is what the Delhi High Court came to the conclusion in this case, in Dr. Reddy's case. But another coordinate bench of the Delhi High Court recently expressed certain reservations on that view, and the court said that, look, Girdhari Lal Gupta's case was a case under the Designs Act. Now, the court noted that there is a difference in scheme of the Designs Act and the Trademarks Act. And pertinently, while the expression High Court is defined under the Designs Act, there is no definition of High Court under the Trademarks Act. And the court said this merits some detailed consideration as to whether this omission by the legislature is intentional or is it of no consequence at all, but this needs to be examined. The court said that this case poses certain further questions because when an appeal can be filed under the Trademarks Act, Section 91, against any order by the registrar, then the Section 91 also uses the expression, the appeal shall lie before the High Court. Now, in the cases of appeal, the High Court would only mean the High Court where the office of the registrar was situated. So an appeal by the order of the registrar of trademarks at Delhi would obviously lie to Delhi High Court. But that same expression, the High Court, when used in Section 47 and 57, which are provisions relating to rectifications or cancellation, the court said that can we say that the same expression in the statute when used in Section 91 would mean a High Court X, but when the same expression is used in other provisions in relation to rectification, it can mean High Courts Y and Z or High Courts all over the country where the dynamic effect of the registration has been felt. So the court said there are various issues in this that require more careful and detailed consideration, and therefore the issue has been referred to a 5-judge bench, which the Honorable Delhi High Court is examining as of now. In the meantime, there was a decision that came in from Madras High Court, where the judge agreed with the decision given in Dr. Reddy, and the High Court held that essentially the High Court within whose jurisdiction the interests of the trademark holder are negatively impacted must have the jurisdiction to hear any application to cancel the same, and the person need not be compelled to go to that High Court in the state where the relevant trademark office is that granted that registration. Now, why am I even highlighting this as to why is this issue even important and why it has assumed certain significances? Because under the 1958 Trademarks Act, prior to 99 Act that is currently in place, anyways, the jurisdiction to decide appeals and rectifications was with the High Courts. When the 99 Act came in, Intellectual Property Appellate Board was established, and it started functioning in 2003. Now what IPAB, and the jurisdiction to hear all appeals and rectifications were transferred to IPAB, and the jurisdiction of the High Courts was barred. Now, under the 99 Act, when IPAB was formed, IPAB had drafted a uniform set of rules that applied to kind of all of these proceedings. And irrespective of whether the matter was emanating from Ahmedabad or from Chennai or from Delhi or from Mumbai or from Kolkata, there was one set of rules to deal with it. But when the Tribunal Reforms Act came in and IPAB was abolished in 21, and all of these matters then started to get transferred back to the High Courts, the High Courts did not have any rules to deal with these petitions anymore. So under what form this petition will be filed, what would be the fee, what is the procedure that is going to be applied to it. So what happened was that various High Courts started framing different rules to govern these proceedings. The Delhi High Court took the lead, and Delhi High Court Intellectual Property Rights Division rules were formed in 2021, followed by Madras High Court. And we can see that already there is some kind of divergence in these rules. So for instance, in Delhi, if you file an original rectification petition before the Delhi High Court, after the pleadings are kind of completed, filing of evidence is not a matter of right, and the courts and the IPD rules provide that it can be done only when directed by the court. While in the Madras High Court rules, the position is a little different, and the court may dispense with the oral examination only with the consent of all the parties. So if even one of the parties disagree, evidence has to be led. Now, rules have recently been published by the Calcutta High Court, and we know that Bombay High Court and Karnataka High Court are also in the process of framing these rules. Now, if all of these matters are going to come to the high courts, and even high courts that do not have original civil jurisdiction, for instance, like Madhya Pradesh High Court, if the dynamic effect of the registration principle really takes its place in the IP jurisprudence, then tomorrow our high courts at Madhya Pradesh would also be, or other high courts that do not have original jurisdiction, would also be hearing these rectification petitions, cancellation petitions, and in any event, those suits under the Patents and the Designs Act that have been transferred. So therefore, what is the need of the hour is that we need a uniformity in procedure, and that is where most of the high courts are kind of heading. But what all of this really underscores is that the validity of the underlying right is really at the core of the issue in any intellectual property dispute. So whenever any IP suit comes to any court, the first question that really comes up before any final order is granted, of course, interlocutory applications are decided on different considerations, and the next session, our speakers will go into that. But before any final order can be passed, the validity of the right has to be considered. Now, I just want to highlight here that prior to the Tribunal Reforms Act, the validity questions were raised either before the Registrar of Trademarks or the IPAB. If there was, this issue has been raised, there would be stay of suit under Section 124, and then the finding as to validity becomes binding upon the parties, and the court was to dispose of the suit conformably to such order. So a civil court really has no role to play in determining the final validity of the underlying right. It gets relegated to either the registrar or the High Court exercising a different jurisdiction. But post the Tribunal Reforms Act, when all these cancellation petitions went to the High Court, these questions started to pop up that, for instance, for us in Delhi High Court, where the original suit is also pending, the commercial suit is also pending in the commercial division in the High Court, and the cancellation is also there. So some of the courts took a view, some of the judges took a view that probably we don't need to stay the suit anymore, because the suit is with us and the rectification is with us, so both the proceedings can be clubbed and both can be heard together. Now, a division bench of the Delhi High Court has recently said the statutory mandate is that the suit needs to be stayed and the validity needs to be decided first, and therefore both cannot be clubbed and tried together in that sense. Now, what happens, this brings us to question that, if it's in a normal suit proceedings before the court, and I want to marry a little bit of arbitration here, because I felt that there are certain issues that in the arbitration that do not provide for, in the trademark statute, that do not provide for what would happen if the proceedings are before an arbitrator vis-a-vis when the proceedings are before court. So just to give you a small example here, consider that in a family settlement kind of situation, there are two family groups and they kind of demarcate their rights in a particular trademark. The family settlement agreement has an arbitration clause. And let's say a suit for infringement is filed by family A against family B. Now, because there's an arbitration agreement, the parties get relegated to the tribunal. And the petitioner before the tribunal relies upon his contractual rights and says, look, I have a right under the agreement. They agreed they're not going to use this trademark for these particular goods. Now the respondent pleads that this is what the agreement says, but I have a registration. I have a registered trademark that says I have a right to use this trademark, an exclusive right to use the trademark in relation to these goods all over the India. And that registration is valid. Now, plea is raised by the petitioner that, okay, you have a registration, but I have a contract signed by you that runs contrary to that registration. So therefore, your registration is actually bad in law. It is contrary to the agreement. It is in fact liable to be rectified. Now, the question that arises is that can the arbitral tribunal grant a final relief in the matter? Because there is no provision for stay of proceedings. Section 124 only provides for a situation where a suit for infringement is pending. Now here, there is no suit for infringement. There are proceedings before an arbitrator. So there is no statutory provision by which the arbitral proceedings can be stayed, while in the meantime, the High Court or the registrar can decide upon the validity of that right. And tribunal is not empowered to decide the validity. So, as we know, Honorable Supreme Court in Vidya Drolia had said sovereign functions of the state and the correctness and validity thereof cannot be made subject matter of the arbitration. Now, registration is granted, it's a sovereign function of the state, it is granted by a statutory body. So, the correctness or otherwise of that registration, the arbitrator cannot decide, but a single judge of the Delhi High Court in Vijay Kumar Munjal took a view that what we have to see is what is the nature of the dispute, because there could be certain disputes inter se the contracting parties that may only involve a right to use the trademark. And those disputes may be arbitrable because there may not be any challenge to the underlying right. Now, the matter was referred to the arbitral tribunal, and the tribunal finally came to the view, and since the matter has come in appeal before the High Court, so therefore this award is public, that the question was, could the tribunal grant a relief that prevents the respondent from exercising a statutory right? And the tribunal said, well, I cannot grant an injunction, a final relief, restraining the respondent from exercising a statutory right unless that statutory right is in some manner invalidated in the procedure that is provided in the law. I cannot circumscribe the registration or place any limits on it. Various different jurisdictions have different ways of dealing with as to whether IPR disputes are even arbitrable or not. So, for instance, Switzerland and Belgium considered to be more pro-arbitration jurisdictions. They consider that claims of even validity of IP rights are arbitrable, and the awards over the invalidity can be enforced even erga omnes. Canada and UK, on the other hand, take a more middle approach, and they hold that validity claims are arbitrable, but the effect of that is limited only to the parties and does not apply to the world at large. I want to just very briefly touch on the criminal enforcement measures available in our law and just highlight one challenge that we have. As one of these studies recently highlighted, counterfeiting constitutes about 25 to 30% of our market. So, in fact, every third product that we are buying probably is a counterfeit in this country. And considering that our trademark and copyright legislations both provide for even infringements of copyright or infringement of trademarks to be offenses and recognizes and provides for an imprisonment for a term which will not be less than 6 months, but which may extend to 3 years. But what the gap really has been that while under the Copyright Act, the offense is cognizable in the sense that any police officer of the rank of sub-inspector or higher, if he's satisfied that an offense under Section 63 in respect of infringement of copyright has been made out, then he can go ahead and do search and seizures without any warrant. But under the Trademarks Act, there are two limitations that have been imposed. One is, if you see the proviso that is provided under the Section 115(4), it says that provided that the police officer before making any such search and seizure shall obtain the opinion of the registrar on the facts involved in the offense relating to the trademark. So essentially, if any brand owner has to take any action for the infringement as any criminal measure under the Trademarks Act, before police officer can take cognizance of that offense and do any search and seizure operations, an opinion of the registrar is made mandatory. Now, this obviously completely frustrates the process because taking that opinion involves a lot of time, and that by the time that opinion would come from the registrar, the purpose is frustrated and the counterfeit goods have vanished or the information is leaked out. So that is one limitation that is there, which a lot of organizations like even INTA and other various others have been pitching to the government to bring in reforms in this area of law and to say that this should not be a requirement because there's no such requirement under the Copyright Act and there is no reason why it should be under the Trademarks Act. And also, the jurisdiction given is only to an officer not below the rank of Deputy Superintendent of Police, as opposed to a sub-inspector, what is under the Copyright Act. So we, in fact, 4 or 5 years ago, we filed an application under the Right to Information Act asking the Trademark Office as to how many of such complaints have you received in a particular year, asking for the opinion of the registrar under 115.4, and how many of these have you disposed of, in what time frame? While the time frame was not provided, but what the statistics reveal is that less than 50 complaints in a period of 5 years, 50 such opinions in a period of 5 years were even asked for, as opposed to hundreds, if not thousands, of actions that are taken under the Copyright Act, wherever any logo or a symbol has been copied. But Copyright Act has its own limitations. So if the trade dress and you know, the logo, etc., has not been copied, but it's a case where somebody has imitated your trademark, you're only probably left with civil remedies. You do have criminal remedies, but then it will take a very long time, and the purpose gets frustrated. The search and seizure operations do not become effective. So briefly, this is my presentation. Thank you very much for hearing me, and I'll pass on to you.
Thank you, sir. I now have the privilege of inviting Honorable Chief Justice Sanjeev Sachdeva to illuminate us with his insightful perspectives. My Lord.
I'm in the same dilemma which Honorable the Chief Minister was yesterday. And he said, Aage wala bhi sahi. Because that is where I'm left with hardly anything to say after Gaurav has given such an elaborate presentation on all subjects. For the people who are from abroad, this is the view of our High Court in Jabalpur. So it's a over 100-year-old building, and some of the courtrooms are very beautiful. Coming back to jurisdiction, which Gaurav talked about, Section 134 Trademark Act, 104 Patent Act, 62 Copyright and 22 Designs Act. As he mentioned, normally in a suit, the jurisdiction is decided by Section 19 and 20 of CPC, that is where the defendant resides or where cause of action arises. So that's the general principle applicable all over. And they have to be instituted not below the level of a district court having jurisdiction. In some of the high courts like Delhi, Bombay, and Chandigarh, there are original jurisdictions. So suit can be instituted either before the district judge or before the high court, depending on the pecuniary jurisdiction. Exceptions to the rule are Section 104 of the Patent Act, which Gaurav just mentioned, that if a counterclaim is filed, then the suit shall stand transferred to the high court. I don't know whether in our high court we have these provisions for entertaining such a suit. And then 22 Designs Act, if a defense is taken, then it is transferred again to the high court. Jurisdiction is defined under 134 as to district court having jurisdiction within local limits of whose jurisdiction at the time of institution of the suit or other proceeding, the person instituting the suit, that is the plaintiff, or where there are more than one persons, one of them actually works, resides and carries on business or personally works for gain. Similarly, in Copyright Act, it can be additionally filed where the plaintiff is situated. Now, there may be an issue. What would be the situation if there is a company? For example, a company, we normally know that a company has a head office, registered office, corporate office. So they are ordinarily carrying on business wherever they have an office. So when this amendment came in the Act, so people started saying, all right, I have a branch office or a dealer in a remote location. So let me file a suit there because I'm the plaintiff, I have office staff there, harass the defendant. And that's the easiest thing to do. Harass the defendant, he can't come there and effectively defend the suit. So then issue arose because companies can certainly have more than one offices. This was resolved in ultra home construction, where on the left, if you see, A indicates the principal office. So if principal office is in court having jurisdiction at place A, if there is no subordinate office, cause of action arises at C. Under 1920, suit can be filed at C, but under the 124, it can additionally be filed at A. If principal office is A, subordinate office is B, cause of action arises at A. Now this judgment says you can only file it at A. not at the subordinate office. If it's principal office, subordinate office at B, and cause of action arises at B, then perforce has to be filed at B. You don't have a choice. So again, it linked cause of action with your place of business. If it's principal office A, subordinate office B, cause of action C, of course, C you can because of 1920. Additionally, at the principal office. So that is how the court explained. Then came Radico Khaitan's judgment, where the issue was Goa versus GO4. That was a dispute, and suit was filed in Delhi. It was an liquor case, and for liquor you have to have the excise label approved. So excise label was approved in the office at Mumbai. Registered office of defendant number 1 and 2 were at Mumbai and Pune. So 1920 it could have been filed either at Mumbai or Pune. Manufacturing and marketing was taking place in Maharashtra. Plaintiff had a registered office at Rampur, Uttar Pradesh, corporate office at Delhi, and Mumbai only had a branch office. And the argument was that the dynamic effect of clearance of label was felt in Delhi. So this was a novel argument because in Delhi the trademark lawyers come up with very ingenious arguments. So it's a dynamic effect. So then the court, and the label, and unless you have a label approved in a state, liquor can't be sold in that state. So the label which was approved said for sale in Maharashtra state only. And the sales were only happening in Maharashtra. There was no allegation that the sales were happening in Delhi. So the court held that the contention that dynamic effect of obtaining a excise clearance at Mumbai, if it can be felt at Delhi, it will also be felt at Maharashtra, in Mumbai. So said, go back to Maharashtra, and only courts at Mumbai would have jurisdiction. So this is how novel ideas come up. And let me tell you, once you look at trademark lawyers and trademark laws, they're so interesting. But since Gaurav has covered most of it, I'm going to cover a slightly different concept. What is the concept of trademark law? We all studied trademark deception. And let me tell you, we are experts in law. But the concept of trademarks law is average intelligence and imperfect recollection of a consumer. Why do we use this? When you go into a market, you ask for a product. You may ask for it by name. You may also remember that it is a product with some distinctive feature, maybe a red line, maybe a color scheme. So you ask for it. So, and over time, people forget. If it's something you regularly use in daily life, probably you'll never get confused. But sometimes what happens is you go to a shop, you'll say, I remember that I had bought this couple of years ago, bahut acha tha. Now you faintly remember what were the features of that product. So it's an imperfect recollection of an average intelligence, because we are dealing with a person, a consumer who has average intelligence, not an exceptional brain who will remember all distinctive features. So, and language plays a very important role in our understanding of products and understanding of things. For example, this was the banner. Long live our beloved leader. So that's how it happens. So if you may make a mistake in the spelling. Dragon Mom Corner. Now at Delhi, momos are very famous. I don't know whether in Maharashtra or Madhya Pradesh they are famous or not. So, and Sharma Sweets and Snakes. So we have snacks. So these are spelling mistakes, and spellings can play a very important role. Now, lack of English knowledge can sometimes be disastrous.
Das hier ist mein Sektor. Das hier ist das wichtigste Gerät des Küstenwächters. Das Gerät und das Gerät. Überlebensradar.
Mayday, Mayday. Hello, can you hear us? Can you hear us? Can you... Over. We are sinking. We are sinking.
Hello? This is the German Coast Guard.
We are sinking. We're sinking.
What are you thinking about?
that is what happens when you use language like this. Now, can you read this? I couldn't believe that I could actually understand what I was reading. The phenomenal power of the human mind, according to a research at Cambridge University. It doesn't matter in what order the letters in a word are. The only important thing is that the first and last letter be in the right place. Rest can be a total mess and you can still read it without a problem. This is because the human mind does not read every letter by itself, but the word as a whole. So a spelling error here or there can change the trademark, can change the concept. Now, but again, human mind is very complex. Can you read what is written? Focus on the blue or the yellow separately. If you focus on yellow, you'll see it says optical. And if you look at the blue, it says illusion. That's how these pirators play with your mind. Now, who's sitting? The boy or the girl? Well, we've got, like I said, we've got experts sitting here, we've got trained minds, but we have to look at it from the perspective of an average intelligence person. Well, that is again, well, I don't know, I don't want to comment on it, but let's look at this. Just count the number of persons standing, 3 to 5, 7, 8, 9, 10, 12. There are how many? 12 of them, right? Now count. 3, 6, 8, 11, 13. We'll make it 13 again. So wish we could master this. Even punctuation marks matter when you interpret a document. Following words were written with the direction to punctuate them. Now the men wrote, woman without her man is nothing. And the women wrote, woman without her man is nothing. So a punctuation mark does make a difference. In nature, we call this a miracle. In trademark law, it's an infringement. The more distinctive the mark, you say this is a tip that we have. If you remember, we have something called fridge in our house. Fridge was actually a trademark, but it became so common to trade that it lost its protectability. A generic mark, for example, carpet cleaning company. So it's a scale of how generic a mark is, how distinctive or fanciful a mark is. So whether it will be protected or not. If it's a generic mark, then comes the level of a descriptive mark, Singapore Airlines, for example. Then a suggestive mark, Burger King. Then an arbitrary mark completely not connected with the product, Apple for phones and computers. So that will have a very protectability value. Now then there are fanciful marks. You may wonder what are fanciful marks, so I have some examples here. There is this brand called Kuch Nahi. Kuch Nahi for a foreign friend means nothing. So there is a joke going around. There was this person who used to drink, and every day he'd come back home and his wife would ask him, what have you had to drink? So he would feel very guilty. So he came up with this idea and this brand name which says Kuch Nahi means nothing. So she would ask him, what have you had? He'll say nothing, Kuch Nahi. So this is a very protectable mark. Then we have this Chor Baniye Ki Dukaan. So these are names. Bevkoof Hotel. And this is for Mr. Bansal. Thagu ke laddu, because he was mentioning that Thagu ke laddu. Aisa koi saga nahi jise humne thaga nahi. Then Zakhmi Juton ka Aspatal. Dr. Ramji Lal. Now, when we look at some marks as to how, now this is something we have every day. That's right. Or do we have this every day? Imagine how people come up with this idea. See, if you remember that I had butter which was yellow and blue packet, and 2 years down the line you want to go and buy it, you will not be able to find out, remember which one was it. So that's how the trade dress and all things do make a difference. If your children get hurt, you use this. Or is it that you use? Now this is for someone who like a soft Killer's cornflake and Kellogg's cornflakes. See how identical they are. If you keep them side by side, you may be able to pinpoint. But if you look at it separately, you may not be. So this is the washing powder. The women might identify, but men will have a difficulty in understanding what we are getting at. Similarly, this is a drink we have, 7-Up. So this is how these people come up with these ingenious ideas of changing a little bit of thing here and there. Now this is being extensively used in cyber crimes, where they will, instead of an L, put an I with a full dot on top, which looks like an L in a domain name or something. This is McDonald's. So all these people come up with amazing ideas to sort of pass off products. Now, which one is the genuine one? So if somebody is, if a person who's not very literate in the language is given a bottle on the right, he might accept it as a genuine product. So that's where the trademark law comes in. We have to be very careful in dealing with these kind of things. And people come up with amazing ideas. This is biscuits that we have. Does anybody think this is the right one or the wrong one? Not the common, what is wrong with it? What should it be? 50-50. So these are people who have biscuits every day. Britannia is 50-50. But somebody who's not very literate, he'll go by, kuch hai, percentage 100 banti hai, 60-40. So they'll probably have it. Kits, Wicks. And trade dress and passing off. Now people come up with amazing ideas. Now do they look similar? Would this be injuncted? I think for the asking. So similar. Now people have come up with Facebook Chartwala, BBM Tikki, Orkut Save Puri, Skype Mail, everything, Gogola. Hotel Google, Facebook books and stationery. Now these are some of the products. Yesterday we heard about shape as a trademark. Now these are protected marks. You have a design of a bottle, you have a shape of a bottle, like Coca-Cola. Nobody can use this bottle. Christian Dior has that perfume bottle. These are protected. Amazing marks. Now there are non-traditional marks. We are looking at word mark, name mark. This is a pattern which Burberry uses. This is protected. Nobody can copy this. It's not a trademark in that sense, but it's become so connected to the source that it is protected. Sound marks are protected. We have heard this in all Hollywood movies. This is protected, a sound mark as a trademark of that MGM company. This is a mark which is protected. Nobody can copy it. So trademark, anything and everything which identifies a product with the source becomes a mark. Even this is very famous when we were kids. I don't know, our children had Shinchan and Shinche and things like that. Now, copyright can be violated even through advertisements. You have an advertisement and there are suits filed that copyright has been violated.
चलो चलो सीने की जलन, इन्हें चाहिए नया गैविस्कॉन जो दे सीने की जलन से ठंडक भरी राहत सिर्फ 3 मिनट में। सिर्फ गैविस्कॉन बनाए अनोखी सुरक्षा परत जो काम करे 4 घंटों तक और दे लंबा आराम।
इसीलिए मेरी सलाह सिर्फ गैविस्कॉन।
गैविस्कॉन, तुरंत राहत जो आप महसूस कर सकें।
This was the plaintiff's advertisement. And the defendant's advertisement.
चला रे चला 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 रे चला चला अरे चला रे चला चला।
एसिडिटी वाली आग तो पेट का फायर ब्रिगेड बुलाओ। पुदीन हरा फिज, इसमें है लेमन और पुदीने की कूलिंग पावर जो एसिडिटी की आग बुझाए और पेट रखे ठंडा।
ठंडे का मजा आया।
पुदीन हरा फिज, पेट का फायर ब्रिगेड।
So the argument was in the first, there were these firemen coming, in the second this fire brigade and firemen was used. So this is a violation of our copyright. Now I'm leaving it to you to guess what would have happened, whether injunction would be granted. Some of them are borderline cases. Initially it was granted, but then there was an issue. Now there is copyright in songs. I'll come to this later. I'll come to this one first. Now recently there's this controversy of When I Was Your Man sung by Bruno Mars and Flowers sung by Miley Cyrus. First song versus the second, and that controversy just started. Now that's not all. There's this case which happened in Delhi High Court.
I wanna give you what you got. I wanna give you, I say you're not a hot.
Could you make out that there were actually 2 female singers? Nobody could. So this was a case which was filed by Neha Bhasin. And she was invited to a studio to record the song. She recorded the song, but she wasn't shown as the singer. Then another singer was called, and then when the song was released in the movie, the second singer got the credit for it. And she filed a case saying that it's actually my voice which is used in some parts of the song. So the judge segregated the sound layers and then found out that yes, actually it was her voice which was used in some sounds, and that he did because of the way Chakhna was said. Now the plaintiff was a Punjabi, so he said Chakhna and Chakhna. So there are 2 different words and 2 different sounds. That's how the judge decided. So these are very complex cases which will come up. And sometimes these copyrights are violated through advertisements. Sorry, they have comparative advertisement, disparagement. What is disparagement? When you are demeaning somebody else's product by your advertisement, showing yours to be better. This is something I was mentioning yesterday. versus Pepsi.
टाइट है खुशबू है और सफेदी भी और क्या चाहिए हम
मम्मी आंटी चौक क्यों गई?
डाइट से कहीं बेहतर सफेदी दे रिन अब चौंकाने वाले दाम में नया रिन सिर्फ 25।
See, disparagement.
Never seen the sky so blue. The birds are singing, I got nothing to do. Hey, 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 it's just a sunny day. La-doo-da-ba-da-da. Ain't no clouds up in the sky. I'll dream them up and watch my daydreams go by. Hey, 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 it's just a sunny day. Ain't got time to worry. The sun is gonna shine all day. I'm not gonna hurry. You can tell the company they can keep my pay.
Now, in our AI world, I couldn't stop without discussing about this. Artificial intelligence is coming in the forefront. Is AI co-authored artwork protected? Yes, that's him. December 1st, 2021, Ankit Sani is sitting here in the room. He filed an application to register a claim in AI-created work. In the application, he listed two authors, himself as the author of the photograph, 2D artwork, and Raghav artificial intelligence painting app. Now, this was his photograph on the left and Vincent van Gogh on the right. And AI created this. So you can wait for the next slide. It'll give you a composition of both. So we may think that this is hardly anything. Right? Maybe it's not too much of an image, so what. But this is just a tip. It's a starting point. We're looking at something like this. You can take this. This is there, a composite of all. So this is just a starting point. AI is now being used very often. And we may say, so what, it doesn't seem to be anything much. Canada and India granted copyright, and US has denied it. That means the officials in Canada and India found it to be protectable. And this is just the beginning. And we are at a starting point of this. This is going to be actually an eye-opener.
The joy of connecting with your loved ones, browsing the web, or even playing games using only your thoughts. This is made possible by placing a small, cosmetically invisible implant in a part of your brain that plans movements. The device is designed to interpret your neural activity so you can operate a computer or a smartphone by simply thinking about moving. No wires or physical movement are required. By participating in the PRIME study,
now, with such an AI implant, we may be able to imagine and create any form of artwork. Now what happens is when you think of a painting or think of an image and you sit down to draw it, you're not able to draw it. But if with your mind you're able to create artwork, create music, create photographs, create paintings, and it is with that kind of an implant, with your mind you can operate a computer. So who would be the author? Would it be protected? These are challenges which will come up. So you'll have, this is food for thought. So you have to rake your brain, the natural one and not the one with the implant. Steve Jobs said people who are crazy enough to think they can change the world are the ones who actually do. Thank you.
Thank you, my lord. I now respectfully invite the chair or co-chair at their discretion to kindly deliver the closing remarks and reflect on the key insights from our discussions.
Well, we had a very lively session, both by Mr. Miglani and Mr. Justice Sajdeva, and especially Mr. Sajdeva. The clips which have been shown were quite unique, and it goes right into your mind. It gives you an insight that how the product and the language is manipulated to infringe the laws. I think we have all learned and have enriched ourselves in this section. Thank you.
Thank you, my lord. As we delve into this crucial discussion on enforcement mechanisms, we lay a strong foundation to explore modern forms of injunctions that court has innovatively crafted since 2019 to stay in step with the evolving times. That is, Mariva injunction, Anton Pillar order, John Doe orders, dynamic injunctions, geo-blocking, and global injunctions. These powerful legal tools exemplify how the judiciary continues to mold remedies to address the challenges of modern times. Before we wrap up, I would like to take this moment to express our profound gratitude to our esteemed dignitaries for the invaluable times and generous insights. Your contributions have significantly enriched this session, leaving us with much to contemplate and carry forward. I request all the dignitaries and the participants to join us for the tea, and participants are also requested to resume their seats within 25 minutes, allowing us to commence the session as promptly as scheduled. Thank you. Jai Hind.
So many concepts and in such a simplified way. Now exactly can relate to what you were saying.
Hello, hello. Oh, are you there, Judge Kim? Can you hear us? No. Ah, there you are. Good morning. You need to unmute, please, Judge Kim. No, you're still on mute.
No?
Yeah. Yes.
How about now? Can you hear me?
Yes, we can hear you.
Okay, great.
Perfect. So, are you going to follow the presentation with your slides on your computer, or did you print them out? Because we will have your photo, like we will have you on video up on the screen the whole time.
Okay, wait a second. Oh, wait a second.
Where's the
인터네션 때문에 문을 살짝 열어놓을 거거든. 너무 크게 소란 피지 말아줘. Hello everyone. Hello from South Korea. Hello from Seoul, Korea. I am very pleased to be here and to be given this opportunity to share some international perspective as well as Korean perspective. It would be much better if I were there, but anyway, thank you for having me today. Let's start with the preliminary injunctive relief in the statements.
Good afternoon, everyone. Participants are requested to please get seated. We are about to commence with our third technical session. I request Shri Krishnamurthy Mishra, Director, Madhya Pradesh State Judicial Academy, to please escort the dignitaries on the dais. I invite the resource persons to the dais. Good afternoon. Welcome to the third technical session, which is Evolving Landscape of Injunctions, Damages and Enforcement of Awards. This session shall be chaired by Honorable Shri Justice Sanjay Dwivedi and shall be co-chaired by Honorable Shri Justice Maninder Singh Bhatti, Honorable Shri Justice Dinesh Kumar Paliwal, Honorable Shri Justice Prem Narayan Singh, and Honorable Shri Justice D.N. Mishra, and shall be addressed by the resource persons, Ms. Iris Ganthar, International Trademark Association Positions, Mr. M.S. Bharat, Kriya Law, and Judge Young Kim, High Court of Korea, who will be joining us via virtual mode. I would like to begin with the felicitations of our honorable dignitaries on the dais. I request Shri Mahesh Kumar Sharma, Principal District Judge Sagar, to please felicitate my Lord Honorable Shri Justice Sanjay Dwivedi by presenting his lordship with a planter. Thank you, sir. I now request Shri Virendra Singh, Principal District Judge Guna, to kindly felicitate my Lord Honorable Shri Justice Maninder Singh Bhatti by presenting his lordship a planter. Thank you, sir. I now request Shri Vaibhav Mandloi, Principal Registrar Vigilance, High Court of Madhya Pradesh, to please welcome my Lord Honorable Shri Justice Dinesh Kumar Paliwal by presenting his lordship a planter. Thank you, sir. I now request Shri Manish Sharma, Faculty Member, Madhya Pradesh State Judicial Academy, to please welcome my Lord Honorable Shri Justice Prem Narayan Singh by presenting his lordship a planter. Thank you, sir. I now request Shri Devendra Prasad Mishra, Special Judge Indore, to please welcome my Lord Honorable Shri Justice D.N. Mishra by presenting His Lordship a planter. Thank you, sir. I now request Shri Alok Mishra, District Judge Sagar, to please welcome Ms. Iris Kanthar by presenting Madam with the planter. Thank you, sir. I now request Shri Abdul Qadir Mansoori, District Judge Rajgarh, to please felicitate our resource person, Mr. M.S. Bharat, by presenting him a planter. We also have a resource person who has joined us virtually, Judge Young Kim. He is from Intellectual Property, High Court of Korea. Sir, we welcome you to our technical session. Am I audible to you, sir? Sir, Judge Young Kim from High Court of Korea. Hello, sir. Am I audible to you?
Yeah, I'm here. I can hear you.
On behalf of High Court of Madhya Pradesh and Madhya Pradesh State Judicial Academy, I extend a cordial welcome to you, sir. We are very glad that you have joined us.
Thank you so much for having me today. It's my great honor and pleasure to be here. It would be much better if I were here today, but anyway, so happy today to be here. Thank you.
We hope that we get a chance to welcome you in person sometime, sir. Commencing the session, I would request the Honorable Chair to please deliver the opening remarks.
Sorry, I beg your pardon?
Sir, I will be inviting you for your address.
Honorable Justice Sanjeev Sasdeva, my brother judges, co-chair and resource persons, we welcome you for this session. The information and knowledge, according to me, never harms anybody, but it becomes your asset. So we request that everybody should be attentive and increase your asset by the information or knowledge that will be given by my resource person, so that you will become a richest person after some time in this subject and in this field. So we ask resource person to start this session. Thank you.
Thank you, my lord. The first speaker for this session is Ms. Iris Kanthar. I would like to give a brief introduction about our resource person. Ms. Iris is a licensed German lawyer who has been specializing in IP for over 20 years. Originally from Germany, she initially worked as an attorney at an IP boutique in Hamburg before moving to Montreal in 2004, where she was a partner at a local law firm until 2013, after which she briefly worked as an in-house lawyer for Time Inc. in New York. As International Trademarks Association Director, Brand Enforcement and Sustainability, she handles legal research and advocacy initiatives for trademark enforcement issues, including oppositions, cancellation, and litigation topics. She also leads the International Amicus, Unfair Competition, Parallel Imports and Brands and Sustainability Committees, and recently headed a think tank with 10 international judges to discuss the IP judiciary of the future. Some projects she has actively been managing include INTA's International Judges Workshops, supporting worldwide improvement of administrative and judicial enforcement mechanisms, observation and support of developments in international judicial proceedings, legislative amendments worldwide, and treaties such as the Hague Convention. I request ma'am to please address us.
Good afternoon, honorable judges, distinguished guests. It is quite difficult to be speaking directly after Justice Sachdeva's very entertaining presentation, which was very fun except for the joke about the Germans. But we have to get back to the serious issues. So before we talk about the substantive topics, I would like to briefly describe INTA's work to advocate for harmonization of IP laws and best practices. And this is not working. Okay. So as we've already heard from my colleague Gauri Kumar, INTA or INTA is a global association of brand owners and professionals dedicated to supporting trademarks and complementary IP rights to foster consumer trust, economic growth and innovation, and committed to building a better society through brands. And to that effect, INTA continuously analyzes worldwide IP laws and practices and develops recommendations based on the research we conduct with the help of our committees. And where we see gaps in harmonization and protection, we create formal positions on best practices in the shape of board resolutions. Based on the research and these positions taken, we consult governments, IP offices, and other stakeholders on IP legislations and recommend best practices. And why do we do that? Because fostering harmonization in IP legislation and practice provides right holders with effective, predictable IP protection and enforcement mechanisms, ideally in every jurisdiction, which effective and strong protection of IP rights, we've heard that a few times now, encourages brands to invest in jurisdictions and thereby creates economic growth and development. Within this process of protecting IP rights, the judiciary plays a key role. The judiciary is the final instance for right holders in the enforcement of their rights after the administrative process of registration as a first step is concluded. So judges, all of you, will ultimately decide whether and how IP rights will be enforced against violations. And within the judiciary enforcement process, two crucial tools are injunctive relief and monetary relief. The former creates prejudgment protection, and the latter creates a balance and compensation after the judgment is issued. And with that, we move into, excuse me, this is not working. No. Okay. So we will talk about preliminary injunctive relief. As we've heard a little bit from my colleague Gaurav Miglani, preliminary injunctions are one of the most, if not the most important tool for right holders seeking to stop the infringing conduct, preserve the status quo and evidence, and initiate the enforcement of their IP rights. Most right holders' initial exclusive focus in this process is to make it stop as quickly as possible. And as such, this is a priority issue for INTA on behalf of our members, which is why our enforcement committee, currently led by Gaurav Miglani, conducted research on the status and availability of preliminary injunctions in 47 jurisdictions to find out how well, or maybe less so, things are working in different jurisdictions. So we reviewed standards and requirements and practices. We analyzed common denominators and also the discrepancies in order to determine what INTA's formal position should be, and also in order to identify harmonization gaps. So, we found that some of the most relevant factors in the injunctive process for right holders are listed in this slide, namely, the conditions in which ex parte injunctions are granted, which is important to have that option of an ex parte process. The availability and likelihood of the grant of the injunction order. Are they actually granted regularly and frequently? The competent courts, which courts are in charge? Evidentiary demands. What is the level of evidence required for preliminary injunctions to be granted? That is, of course, crucial to right holders. The timelines and deadlines for these proceedings, possibilities of requesting a seizure of goods, the level of involvement of the defendant in the process, and the availability of penalties and fines when injunctions are violated. And finally, a point that we didn't go into, which is security deposits. Does the plaintiff have to submit security deposit before applying for an injunction or before it's issued? So some other key issues and also discrepancies that we found were related to the following factors on this slide, namely the deadlines. In some countries, deadlines to file applications for preliminary injunctions are set by law. In other jurisdictions, there are no deadlines, or they are developed by jurisprudence. This, of course, is key because in most cases, injunctive relief is a very time-sensitive issue. Then the requirements, as I already mentioned, for injunctive relief. In some countries, there's a very high threshold to actually prove the infringement, even in preliminary proceedings. In other countries, there's simply in other countries, it is sufficient to prove that the claimant is highly likely to succeed on the merits. Then the difference between ex parte and when a hearing is required. In most countries, such a hearing of the defendant is required at some stage of the process, but this is a rule that is excused in some certain circumstances, such as when there's an evidence of urgency or there's a danger that evidence might be destroyed. There are also these factors that were very important for the determination what we should do in terms of harmonization or recommendations. Namely, one of the most important issues was the review of the validity of rights. As we've heard before in the presentation, claiming or contesting the validity of the rights in injunctive proceedings can be extremely delaying for the process. And however, many countries still allow for a full review of the validity of the plaintiff's rights during preliminary expedited proceedings. And in other countries, simple proof of registration or use as prima facie evidence of validity of rights is sufficient to allow for the issuance of an injunction. Then time limits for filing motions to grant an injunction. There can be significant delays in some countries, up to months or even 6 months to a year, whereas other countries are very quick and will require only 1 to 3 days to issue an injunction. That's, again, a very crucial factor. The defendant's rights. In some jurisdictions, a defendant must be heard. In others, there will be an opportunity to oppose an injunction at a later stage, but there's always some involvement of the defendant at some point. There's also the question of a compensation for an unjustified preliminary injunction. Again, this is something we didn't go into, but that, of course, is also a defendant's right. Then there's the main action. The question is filing of a motion for the main infringement suit a mandatory requirement? In some cases, the judges set this kind of requirement with a time limit, and in other countries that is not required. So you can see from this brief analysis that despite the fact that injunctions are widely available worldwide, there are still significant differences, and these discrepancies impact legal certainty, efficiency, and predictability for right holders. This, of course, is problematic, especially in light of today's borderless trade and violations, where expedited, efficient enforcement is key to protecting rights and creating a balance against speed and anonymity of e-commerce activity. Which is why we, as INTA, adopted a board resolution due to the importance of this topic for our members, and because of the significant discrepancies we found in worldwide standards. So we adopted a formal position on injunctive relief and recommended certain minimum standards. And these include, but are not limited to, the following you can see here on the slide. Namely, we believe that proceedings should be expedited with short procedural deadlines, including for the issuance of an order. There should be the availability of ex parte proceedings in appropriate circumstances. The applicant should be able to assert a claimed IP right and submit documentary evidence to show that it is prima facie likely to succeed on the merits and that the balance of inconvenience favors the applicant. Provided this burden is met, irreparable harm should be presumed. And a quick note here that we adopted a board resolution recommending the amendment of the Lanham Act in the US to include the rebuttable presumption of irreparable harm, where a likelihood of success on the merits of the case has been found. And that amendment was enacted in Section 34A with the Trademark Modernization Act of 2020 in the US. Then next is, except in the case of obvious invalidity or fraudulent registrations, the court should not be burdened with re-examining the validity of asserted rights. A complete review of all the details of a case has no place in expedited proceedings. So if a plaintiff can establish by means of documentary evidence that a valid right exists and is enforceable, this should suffice for the preliminary process. The defendant's rights are preserved through other means, namely the balancing of rights. The defendant is notified of any ex parte order granted without delay, given the opportunity to challenge the injunction and request an oral hearing or otherwise have counter-arguments considered. Counterclaims contesting the validity of asserted rights should be adjudicated in the main proceedings. Injunctive orders should provide for the defendant to pay penalties for any violations, because there is no enforcement without coercive tools. And of course, most importantly, preliminary injunctions should be available and also obtainable. So with that overview over our position, I'm going to hand it over to my friend, Bharat.
Thank you, ma'am. The next speaker is Mr. M.S. Bharat. I would like to give a brief introduction about our resource person. Mr. M.S. Bharat, founder of Kriya Law, is a highly sought-after IP strategist and litigator with over 23 years of practice before Supreme Court of India, apart from High Courts of Delhi and Madras. In the year 2022, Mr. Bharat was one of the 3 co-opted members of Madras High Court IPR Committee, which drafted the rules for IP division of Madras High Court, and has often been invited as an amicus curiae to assist the Madras High Court and IP Appeal Board over the years on varied IP subject matters. Mr. Bharat currently serves as one of the board of directors of the International Trademark Association for the term 2024 to 26, Vice President of India Group, and International Counselor of Asia Patent Attorneys Association. I request sir to please address us.
Thank you, ma'am. Thank you, Iris. I hope I'm audible. I'm so happy and honored to be part of this august company. As they say, Madhya Pradesh is the heart of India. You are truly the heart of India, center of India, the most green part of India. And I can only start off with a quick anecdote of my early days as a litigation lawyer. We had earlier in the day, Justice Sachdeva and Gaurav were mentioning about section 134 and 62(2), where the plaintiff can file a suit. We had a design infringement case of a beer bottle of a defendant who was in a district called Raisen. And I was based in Chennai. The senior counsel had to come from Delhi. Plaintiff is from Bombay. We flew into Raisen, we got the injunction, the defendant filed an appeal, it came to Jabalpur, and in the Jabalpur court we had to showcase what the products are. To our unfortunate opportunity, the bottles which were brought into the court were filled with beer. And to double it up, it fell down. So the appeal court judge got up and said, "Brushed ho gaya, main ja raha hu." So we waited for 2 hours. The whole court had to be cleansed, agarbatti jalaye, and then he came back and then confirmed the injunction. So in a traditional way, what Iris had mentioned and others are ex parte injunctions. Mostly we look at 3 important parts, that prima facie case, irreparable injury and balance of convenience. That happens mostly where we are all accustomed to real goods, real product, real markets. Koi market mein we find some products. There are permanent shops which have permanent address, so it's easy to identify the defendant and take an action. But if we are fly-by-night operators, koi sadak pe bech raha ho, it will be a problem. And imagine taking this to a internet problem. Imagine there is a big mall. Imagine the internet to be a big mall, and there are thousands and thousands of shops inside the mall, and the mall owner will not tell you who the shop owner is. So how do you sue them? So in the traditional way, about 20 years back, we consumed music by cassettes, which became CD, which became floppy, which became CD, which became MP3. Now everyone is consuming music on the phone by Spotify. Similarly, the videos also are being consumed online through OTT channels. So the nature in which the injunctions have to be granted have to be completely dynamic. And that's why we are looking at dynamic injunctions today for the next 10 minutes, where if there is an online pirater, he's uploading some movie or music, and there is an action taken against that party, you need to know who the party is. So the mall owner, as in the registrar of domains, will not tell you who the owner of the domain is because there is privacy protection. So you have to sue them as something called a John Doe or a Ashok Kumar in India as an unknown defendant. But if you get an order against that unknown defendant, the injunction will apply to that website. The defendant will create a mirror website and move on to a second website. So it's like going to a second shop or a third shop. So we need to keep moving on, and we can't keep filing newer suits. So what globally such a problem has been arrested is by way of dynamic injunctions, where one single order will be granted, and that grant will be applicable to newer websites or newer domain names, which the same party or a mirror domain name is created every time. Every time there is a new website which comes up, the order can actually delegate, say in a High Court of Bombay, Calcutta, Delhi, Madras, it need not come back to the court. They will say master court or the registrar court, they can extend the injunctions against the newer known parties. So if you look at how this dynamic injunction works, is that there is a single order against a roving defendant, so that the domain name registrar, the web hosting services, internet service providers are all covered, so that everyone opens their shield, reveal who the real defendant is, and curb the menace of infringement even though they keep moving. So if you look at how these defendants operate, they register hundreds, if not thousands, of domains which look similar. So on day one, they will upload a content onto a particular website. So if you see the left side column, the first case of UTV software, which was decided by our Indian courts, you will say that bmmovies.to.is, fmmovies.se. So these are similar sounding websites, but they are different locations. So it's like a defendant is raided today with an infringing counterfeit product. He shuts that shop and opens up a new location. And online, the problem is much more complicated because you don't know who's sitting behind these websites. Therefore, the need for a dynamic injunction. I'm sorry. So, the first dynamic injunction which was actually granted was to cover as many as 30 different websites. And then there was a problem whether the entire website should be closed. The early cases of website closure, the defendant would come and say, I have 300 web pages inside one web page. There are only 30 of them which are infringing. Therefore, why do you shut my entire shop? It's like going into a dukan and saying that there are 20 Tide counterfeits for which you can take away the counterfeit soaps of Tide, but why shut the entire shop? But the courts went on to say that there has to be a qualitative effort to start finding out how much of the website is infringing so that there is to be a decision taken whether the entire website has to be closed or only portions of that website which are infringing which needs to be closed. So eventually, the UTV case in 2019, the court asked itself about 5 primitive questions. What are these rogue websites and why are they called hydra-headed? Hydra-headed means like the Adi Sesha, the snake which had 5 or 10 or 15 heads. If you close one head, another 4 or 5 heads will pop up. So that's what it's called, a rogue hydra-headed website. On quality issue, it's a bit subjective, not objective, because they will determine how much of content is violative. And of course, whether we need to treat a copyright infringer offline and online differently, and how to treat these persons. Subsequently, there was development. What happened is, assume that we are all watching Saas Kabhi Bahuti. And then every week there is a new episode which comes. You've taken an injunction order for episode number 134, but our Miss Kapoor will not stop with 134 episodes. She'll have another 20 more episodes to go. So the 135th, 136th, 140th episodes will be uploaded, and then there'll be future episodes and content which will keep being uploaded by the content owner. And every time the owner of the copyright cannot go to the court and ask, there is new content, please protect the new content also. Therefore, future uploads of the same copyright owner will also be included in a dynamic plus injunction. So it's not only dynamic, but it's plus because new content will also be protected of the same copyright owner. Well, interestingly, there's a lot of words which is absolutely opposite of Justice Sachdeva's slides. But this is because this is quote unquote of the defendant's website. It actually is an advertisement which says, why spend your hard-earned cash on cable or Netflix when you can stream the HD movies at no cost? So these are infringers, pirators who are uploading the websites. And the last line says, best alternative to cable and paid streaming services. So come and use the rogue websites instead. So the judge who actually gave the dynamic plus injunction order laid down the law by saying that, look, the infringement is dynamic. The nature of infringement is dynamic and it is not static. It is not sitting in one shop. It is not sitting in one website. They keep moving on. Therefore, the nature of injunction which we need to give should also be dynamic as the infringers can be. So, to actually read only the highlighted portions, the dynamic nature of infringement by the Hydra-headed websites, dynamic plus injunction have to be granted so that the rogue websites or the newer versions can be stopped. So, that is what dynamic plus injunctions have come about to be given. Subsequently, there are fewer more examples where Warner Brothers and Snapdeal cases by the same court, they have granted dynamic plus injunctions for current and future cases as well. The second part of this is anti-suit injunctions. Technically speaking, when two adversarial parties are fighting with each other, one would file a suit and they would ask for an injunction for the other party to be stopped. But an anti-suit injunction is, for example, if a Chinese company is fighting an Indian company, and an Indian company is filing a suit in India, but the Chinese company goes to a Chinese court and takes an order that the Indian proceeding should not be proceeded with, then the Chinese proceeding will be called an anti-suit injunction, stopping the Indian court or the Indian party from proceeding with the Indian proceeding. So it's like a suit against a suit or an injunction against a suit. Eventually, there was a case which happened, but anti-suit injunction means that to prevent an anti-suit injunction is called an anti-suit injunction. There was a detailed order considered by the Delhi High Court, and the learned judge actually goes into the detail and distinguishes what is anti-injunction injunction or an anti-suit injunction. He goes on to say anti-suit injunction is not possible, but anti-injunction injunction is possible. We'll just talk about it in a minute. So an anti-suit injunction is, as I said, is a suit or an order preventing a party from enforcing an anti-suit in another court. But anti-suit injunction is a counter-action to an anti-suit injunction. So it aims to actually oust the jurisdiction of another jurisdiction who's trying to stop us from enforcing our rights here. So long story short, on facts, the left case, which is the Raj Unicall, and the right side Xiaomi case, one was trademarks and another was patents. Both the parties in this case were trying to enforce an Indian trademark before an Indian court or an Indian patent before an Indian court. But the opposite party goes to a Texas court or opposite party goes to a Chinese court and gets an order that the Indian proceeding should not be proceeded with. Then the parties approached the Indian court and said the order in the Texas court or order in the Chinese court is violative of the jurisdiction of this present court, and it can't be ousted because even as a subject matter, the parties before the Indian courts were enforcing an Indian registrar of trademarks granted Indian trademark or Indian patent controller granted patents. Therefore, please do not interfere. So eventually, we need to find out if these proceedings are oppressive and vexatious, and the burden is on the foreign entity to actually prove whether those are forum non-convenience. And the trademark rights being territorial or patent rights being territorial, those rights cannot be agitated by a foreign court, but they have to be tested on Indian soil. I'm skipping these in the interest of time. The second case was InterDigital versus Xiaomi. That is what we talked about, where Xiaomi was a Chinese company. It filed the first case in China asking for enforcement of a standard essential patent. Standard essential patents are a day-long seminar, but those are technologies which are used for multiple parties in the same industry. They agree that there is a standard and they say that they are essential patents. And they were trying to set down certain norms there, but InterDigital came to Indian courts and said, please protect my Indian patents before Delhi High Court. There was an injunction granted, but they went behind their back in the Chinese court and said their injunction has to be granted against the enforcement of the Indian order. So InterDigital came back to the Indian court and asked that the Chinese order is bad, therefore there was an anti-injunction injunction and not an anti-suit injunction. So with that, I would only say that the court held if there is sufficient interest in the list or if there is mere overlap of rights, it doesn't mean that the other foreign court will have a jurisdiction over Indian granted patents or Indian granted trademarks. And Indian granted IP rights can only be challenged in India. With this, I'll pass on the subject to Judge Kim from Korea. He's joining us online from Seoul.
Thank you, sir.
Can you hear me clearly?
Sir.
Yes, Judge
we
Kim,
can,
they are to introduce you. Just give them a few seconds.
Yes, sir. I'll just take a minute more. Justice Vinay Saraf has just joined us. I request Shri Krishnamurthy Mishra, Director, Madhya Pradesh State Judicial Academy, to please welcome my lord by presenting his lordship a planter. Thank you, sir. With this, I move on to the next speaker. The next speaker is Judge Young Kim from High Court of Korea. I would like to give a brief introduction about our resource person. Judge Kim studied jurisprudence at Korea University in Seoul, Korea, and completed LLM IP specialization at UCLA in USA. Afterwards, he was invited to the United States District Court for the Eastern District of Texas as a fellowship judge. He has been in the bench for about 18 years as a judge and appointed as the High Court judge for the IP High Court of Korea in 2021. He also served as the director of judicial policy at the National Court Administration for 2 years. He is the co-author of the book New U.S. Patent Law and currently is serving as an expert member of the Presidential Council on Intellectual Property in Korea. We are elated to have you with us, sir. I request you to please address us. Am I audible, I hope?
Thank you for your kind introduction.
Thank you, sir.
Now can I proceed?
Yes, sir, please.
Okay. Hi, I'm very great. It's my great honor again to be here. And so I proceed with the preliminary injunctive relief practice in the United States. Yes, in the United States, preliminary injunction is one of the most frequently used preliminary injunctive relief. It is pursued at the time of filing a complaint for IP infringement with permanent injunction. And a hearing is needed, which is generally separate from the ultimate merits proceeding. The required elements are generally the same as those for permanent injunction, though the burden of proof for provisional relief requires a clear showing rather than only a preponderance of evidence. Next, please. Okay, then what is the element for preliminary injunction? According to the precedent, the 4 traditional elements should be met in the United States. First, likelihood of success on the merit should be proved, and then there should be irreparable harm if not granted the preliminary injunction. And the third is the balance of projects favors an injunction. And last, the public interest would not be harmed by the injunction. Those are the 4 elements for granting preliminary injunction in the United States. Next. And then there are another preliminary injunctive relief in the United States, which is used to hold urgent situation until the preliminary injunction. That is TRO, temporary restraining order, which is short-term preliminary injunctive relief in the United States and granted if one party convinces the judge of imminent irreparable harm. But interestingly, TRO may be entered ex parte, but only valid initially for 14 calendar days and may be extended one time for another 14 calendar days. Next. Okay, then how about in Korea about preliminary injunction? Yes, Korea also have preliminary injunction, but in general, in Korea, preliminary injunction separately pursued before filing a complaint for IP infringement, and in principle, hearing is needed, except when there is just any situations under which the purpose of preliminary injunction is not attainable. And ex parte injunction is hotly granted. Ex parte injunction is actually very, it should be very uncommon, right? And elements for preliminary injunction, are stipulated by the law. which means there should be infringement or likelihood of infringement of IP. So it is very similar to element 1 in the United States. And second element in Korea is need for preservation. Need for preservation is very broad word. So, but in detail, it is very similar to factor 2 to 4 in the United States. Like, yes, there shall be granted especially to avoid a significant damage on the right or to prevent an imminent danger or where other necessary reasons exist. Next, please. So, the need for preservation should be explained in the actual case. So the Supreme Court held like this. It should be determined at the discretion of court, taking into account the interests of parties in granting or denying the request. The necessity for preservation should be determined more carefully. Therefore, if there is a strong likelihood that the patent would be declared invalid, it would be prudent to dismiss a preliminary injunction in consideration of equity between the parties. So not only in patent case, but also trademark case. If there is a high possibility of invalidation of patent or trademark, their preliminary injunctive relief would not be granted in Korea. Next. Yes, another, explanation about need for preservation. The potential of granting future monetary damage alone will not preclude the injunction because IP owner may suffer mental damage due to such as loss of reputation, and these damages may not be fully compensated by monetary compensation. And also in Korea, like in the United States, the public welfare can also be considered whether to grant injunctive relief or not. And the attitude and position of the accused infringer are also taken into account. So, for example, only a limited quantity of products and souvenirs were for exhibition only, and in that case, the injunctive relief will not be granted. Next, please. Next, please. Okay. How about in Germany? Yes, generally, the German practice seems very similar to Korea because the provisional injunction is also granted based on the law, and it's very same as for common injunction. So two elements should be met in Germany. First is infringement, and second is urgency and consideration of interest of both parties. And movement needs only to show prima facie evidence to court, and it must be predominantly probable that plaintiff prevails. And it is generally possible to issue ex parte injunction theoretically, but the constitutional threshold for the ex parte is quite high. And it is possible to find a separate motion for provisional injunction independent of merits proceeding. It's a German practice. Next, please. So, actually in Germany, in real practice, if infringement was found, the preliminary injunction was granted almost automatically. But there was some criticism about that automatic injunction. So the proportionality requirement was inserted into the law. Look at this. In 2021, German Patent Act has been amended to incorporate the proportionality requirement for patent injunctions. And also German Trademark Act, Section 18, Article 3, also has a proportionality clause. Next, please. Okay, so yes, now in Germany, so proportionality defense can be raised during the patent and trademark litigation, so we should be very careful. Okay, now, because we don't have enough time, let's go quickly to anti-suit injunction. As Mr. Barras explained in detail, it's a very hot issue worldwide these days. So I want to revisit this issue. Anti-suit injunction is commonly raised in patent litigation. So in this wireless telecommunication field, there are many standard essential patents, right? So there are global market for standard compliant products. However, IP rights should follow the territoriality principle, which means the IP right is valid only within the jurisdiction where the IP was granted. So, major technology contributors or major trademark owners wanted to many jurisdictions. So there are multi-jurisdictional disputes. It is called jurisdictional tough work. Next, please. Next, please. So jurisdictional tough work is tried to resolve through ASI. ASI, as Mr. Barth mentioned, or other, barring a litigant from initiating or continuing proceedings in foreign jurisdiction regarding the same disputes against the same counterparts. However, ASI may undermine the principle of comity, the respect of each other's jurisdiction between international courts, and might represent challenge from a rule of law perspective, as it may interfere with patent owner's right to property and effective judicial protection. So, those kind of problems was tried to resolve through anti-ASI. Anti-ASI is the court order barring staking or and enforcement of ASIs interfering with the court's jurisdiction, as Mr. Barnes mentioned. Okay, next please. Okay, so in the United States court, ASIs has been issued by 9th Circuit in Microsoft versus Motorola case, this patent case. So, how about in China? Many courts in China have been increasingly willing to issue ASI, saying that you shouldn't go different countries to start another litigation. But other countries like France, Germany, and India have been issuing anti-ASI as a counter action. So like Paris Court of Appeal and District Court of Munich held that ASIs unlawfully interfere with patent IP owners' copyrights under their law. So there are many ASIs and anti-AIs in the worldwide field. Next, please. Then, what is the element for granting anti-suit injunction in the United States? There are two thresholds, and under wider redeadline factors and international comedy should be considered. First, two thresholds. The parts to the dispute are the same. The adjudication of U.S. claim would be dispositive of the foreign claim. Yeah, that is the two threshold. And then, as an under-wider redeadline factors, first, the foreign litigation may frustrate a policy of forum issuing the injunction. And foreign litigation is vexatious or precious, which may threaten the issuing courts in RAM or quasi-land jurisdiction. And those foreign litigation has this other applicable consideration. And lastly, whether the issuance of ASI will be intolerable from an international company perspective. Next, please. If those kind of elements were met, the anti-suit injunction will be granted in the United States courts. But U.S. court, I think U.S. court are very careful about granting that injunction. The last lesson, yes, granting of anti-suit injunction may have a negative impact on the international comedy and mutual trust between international courts. And it may even weaken the fundamental right to access to justice and effective judicial protection. Moreover, it may be a big obstacle for IP holders to enforce their rights and obtain a fair compensation for their innovative contributions to society. However, those kind of problems also raised by anti-suit injunction. So I think the personal opinion is each court should be very cautious to grant ASI or anti-ASI. Thank you.
Thank you, Judge Kim. So back to me. We saw lots of discrepancies in the details, and those discrepancies in the small details make a big difference for right holders when trying to enforce their rights. So in the interest of time, I'm going to speed this up a little bit. The next thing we are going to talk about is another important tool for right holders after the infringement claims have been filed before and also confirmed by a court, and that is monetary relief, also lackadaisically referred to as damage awards. Damage awards, of course, are important for right holders in order to obtain compensation for their losses suffered by the infringement, balance out the risks of the infringing activity. The plaintiff already has the burden of the cost and the time investment of enforcing their rights. So damage awards distribute the financial risk to attribute some of it onto the infringing party. And also, of course, deterring future infringements by showing that the potential consequence might outweigh the benefits of the violating behavior. So once again, we conducted some research to check out what the status in important jurisdictions for right holders was. Monetary relief easily available? Is it being granted regularly or difficult to obtain? What type of awards are being granted in these countries? What are the bases? What can the defendant bring as a defense against damage claims? And of course, very important, how is that damage claim, how is the compensation calculated? Can these orders actually be enforced? Some of the key factors we found, most countries provide for the availability of monetary relief, but there was still 23% of the surveyed countries that do not, or at least where these awards are not easily available. Well over half of the respondents claimed that the monetary relief available was insufficient and ineffective to deter future infringements. Then there was some common types of monetary relief listed here, namely very common statutory damages or actual loss damage suffered, accounting of profits, also payment of a hypothetical license fee or royalties. The calculation, there were certain standards that many countries have adopted, again, like claiming lost sales or profits, claiming the payment of a license fee, the accounting of infringers' profits. All of these were well represented, and over 50% of countries actually allow for a combination of different bases of calculation. So you can claim lost sales and infringers' profits. Also, some countries allow for an increase of awards in case of bad faith, repeat, or egregious infringement. Some of the key problems and issues we identified was, first of all, a lack in understanding. In many countries, both all stakeholders or many parties involved, including lawyers and judges, are still insecure in how to award and calculate damages and monetary relief. Then, of course, a big issue, complex calculations. So how to calculate and also how to prove loss or appropriate compensation. And there were several problems to that category, namely the difficulty of demonstrating lost sales, for example. In many countries, the claimant's burden was to prove that the infringer was actually the cause of these lost sales. That's quite difficult. Then, infringer's profit remedy. In some countries, it was required that the infringer's profit be apportioned to include only those profits directly attributable to the use of the infringing mark. Majority of responding countries indicated the availability of compensation for damage to goodwill, but again, sometimes it was quite difficult to calculate such damage to goodwill. Some of the factors were, could there be a reputational damage? Is there a disparagement of the claimant's products? Are there costs involved to rebrand a product because of that damage, and some other factors? Only 30% of countries provide for statutory damages, and we were told that in many countries, professionals and practitioners thought it would be a good idea to add those as an alternative and to alleviate the plaintiff's burden of proof. Also, actual damages also always mostly fall short of actually compensating for the real loss suffered by the right holder. There are caps for legal fees and there are other restrictions that will not allow for a full compensation. One of the big issues also was that in some countries, monetary relief is subject to different separate proceedings. So instead of having both in one proceeding, you have your infringement that's been confirmed by the court, and with that judgment, you have to go to the next court to ask for damage awards. That, of course, increases the burden on the plaintiff, time, cost, etc. And punitive damages. In many countries, there are no punitive damages, and there's no increase of the damages for bad faith or egregious infringement, which, given the rise, we've heard it a few times now, in bad faith filings and also activity online, etc., an increase for this kind of intentional conduct could be an effective response. So, oh, that was the wrong way. No, it's very slow. Okay. So based on, again, the research and the harmonization gaps we adopted a board resolution to take the position as outlined in this slide, namely, effective and efficient procedures should be in place to secure and enforce monetary relief where trademark infringement has been found. Then, given the difficulty associated with proving loss or damages and the basis for monetary relief, there should be multiple bases available to a claimant and the tribunal for calculating these damages, and they are listed here. We've already mentioned them, either actual damages, losses, lost sales or profits, the license fee, the hypothetical or the royalty fee, infringer's profits, statutory damages, and or compensation for loss of goodwill. Then we believe that enhanced monetary relief, such as exemplary and or punitive damages and or fines, should be available in cases of, for example, bad faith, willful or flagrant violation, or repeat infringement and infringers. It should also be possible, as mentioned, to have claims of infringement and monetary relief adjudicated within the same proceedings rather than requiring two different proceedings. And we also believe that the evidentiary burden on the claimant should be reasonable and not place undue hardship on the claimant. Don't forget that many times the evidence required to prove loss of profits or sales is actually in the hand of the infringer. So while we didn't include this in our board resolution, but accepting a similar standard to the balance of probabilities, or shifting the burden of proof to the infringer after review of a prima facie evidence of a certain amount of loss, might be an option. So to finalize that, there's one interesting case that I came across in Germany. We're talking a lot about the Germans today, but that's how it is. So very briefly, it's called the Ökotest 2 case, which is a decision by the German Supreme Court on damages. Ökotest is a company in Germany that tests consumer products for their compliance with certain sustainability standards. So they'll test, for example, soap to see whether the ingredients are clean, and if they are, then they get this little label that says it's certified Ökotest, and that this product has passed that test. So the company then, this organization then authorizes these manufacturers to use that Ökotest label on their products free of cost. So there was a toothpaste manufacturer that applied this label without having an authorization from the trademark owner. Trademark infringement was confirmed based on the unauthorized use of this label, but the first two instance courts rejected the damage claim based on the fact that the plaintiff did not monetize the license agreement with third parties. Because the license was given to these manufacturers for free, there was no monetization of these trademark rights. So the Supreme Court then overturned the ruling on the damages. However, the most logical claim, which is the hypothetical license claim for the calculation of the damage award, was rejected by the Supreme Court because the plaintiff does not charge for the granting of these licenses in the regular course of trade. So awarding this license fee by way of a damage award would grant the plaintiff an advantage it would not have in absence of the infringement in the normal course of trade. But The court then confirmed that the claims for a disgorgement of the infringer's profits would stand, because regardless of the commercialization of the IP right, it would be inconsistent with the principles of fairness and equity to let the infringer keep the profits derived from the infringing activity, to let the infringement stand without consequence, and also there needed to be a discouragement of future infringements necessary. So based on that, the damage award was granted. And with that, back to
Thank you, Iris. As we mentioned, we have about 4 or 5 statutes for intellectual property in India, which is trademark, copyright, patent, design. And most of them have reliefs for the IP owner by having temporary injunctions, which are ex parte or contested injunctions. And subsequent to trial, there could possibly be penalties or a permanent injunction. Now, the third part, what Iris was mentioning, is the damages. That's a tricky part because in India, most of the courts were not over the years conversant with the concept of damages, because the question the judge would ask us, Bharat, aapko to injunction de diya, damages kyun chahiye? Usne to rok diya. So the whole concept of damages is not to enrich the plaintiff, but to spread the message on 2 counts. One, the infringer has benefited and taken the advantage of the plaintiff's trademark, patent or design, but also to send a message in terms of the punitive damages, to send the message across the market. If you also infringe, you will be penalized by that extra damages, which is called the punitive damages. So I'm going to very quickly run through 5 minutes. I promised Iris I'm going to keep this part 5 minutes. That back in the 1890s and 1940s, we need not prove how much of damages was to be incurred by the plaintiff to be awarded damages. So it was very subjective, it was case to case, and subsequently in the 1940s, at least Bombay High Court, to my knowledge, was one of the first ones to grant an award of damages, which was quantifiable. They said, okay, let us quantify. So account of profit, whatever the defendant has made, please come and prove, so that the defendant will come with all their books to show how much of profit he made or she made with the infringing product. And that would be quantified and given as damages. Subsequently, the Supreme Court followed one of the English courts and said, out of the 3 subparts, one is for the government servants, and second is the wrongful conduct of the defendant. If it exceeds the amount payable to the claimant, then damages should be awarded. So that part, on third part, where they talk about exemplary damages which are awarded by the statute or authorized by the statute. Subsequently, for a brief while, the case of Times stood the test of time until it was reversed subsequently. For that particular period, it was valid. This case, the learned judge thought in his wisdom that, look, the judicial system is overloaded. There are too many intellectual property cases coming in, therefore we need to award damages to bring down the overload of the judicial system. So that was subsequently clarified in the Hindustan Unilever versus the Reckitt case, where they said that, look, exemplary effect is not enough. If it is not sufficiently met by the estimation done by the plaintiff might say, today when I filed the case, I am asking for 2 crore rupees as damages. But by the time the trial is done, the rendition of accounts is given, the proof comes for 10 crores. And then comes the court fee and all, whether you paid it for 2 crores or 10 crores, but that subsequently it can be enhanced as well. But aggravated damages ought to be granted not in substitution, but in addition, whether it is addition or in substitution. So it has to be one of the two, not in addition. And that was subsequently clarified by a chart where in the Philips shaving, the three-headed rotary electric shaver case, the defendant in that case was an organized criminal. What he did was he copied the packaging, he copied the model on the cover of the package as well. There was absolute identity in terms of the packaging, and the level of profits which he had made was unbelievably high. So the court actually said, if you are a first-time infringer, no problem. You walk away with an injunction so that you don't have to pay damages. But if you had the knowledge that you are infringing and you are a first-time offender, then whatever the plaintiff is incurring as costs have to be paid. Third part comes where if you are a repeated infringer, first time you are caught, second time you are caught, then some part of damages apart from injunction and cost has to be paid. Third and the fourth one are actually called the gangster or a thug award, where the repeated offender has a major impact on the plaintiff's business. Then not only injunction costs, but compensatory damages. You need to compensate for the major loss occurred to the plaintiff. But last but not the least, in this case, as in the facts of that case, since it was an organized crime, it was called a gangster kind of a operation. Then they said, not only am I going to avoid you injunction costs, but also aggravated damages. So it went on to several crores. Therefore, I would urge each of you in the state of Madhya Pradesh to start thinking that injunction kafi nahi hai. It has to be plus. I'm giving it back to Justice Kim to come for the international perspective.
Here, Mr. Boras, I think we need to stick to the time. Okay, let's start with the method for damages calculation worldwide. There are typically three major methods for calculating the damages. In the United States, lost profit on the IP holder side is the first method. And the second thing is reasonable royalty, which could be met if there were some hypothetical negotiations between the IP holder and accused infringer. Other than those two methods, in Korea, Japan, and Germany, there are enough methods for calculating damages. The third one is the calculation based on the infringer's profit. If we can prove how much money the infringer got, and then those amount of money can be assessed as the IP holder's damage. But if some portion is not from those kind of IP infringement, and then those kind of money will be removed after that. Okay, next. I want to focus on impacts for punitive damages worldwide. US, Australia, Canada, Korea, and China have adopted this kind of enhanced for punitive damages. But Germany, Japan didn't. It's interesting. Next. Okay, and what's the practice in the United States about enhanced damages? According to Patent Law 35 U.S.C. Article 24, the court may increase the damage up to 3 times the amount fined or assessed, found or assessed. Such a circumstance is committed willful infringement, which means no more than deliberate or intentional infringement. An award of enhanced damage does not necessarily flow from a willful finding. Rather, discretion remains with the court to determine whether the conduct is sufficiently egregious to warrant enhanced damages. But interesting is, differently from Indian court, it is okay, even though it is the first time infringement, if it is egregious or willful. Okay, next. And there are real factors to assist the court in determining whether to award enhanced damages, and if so, by how much the damages should be increased. will be considered to decide. Next, please. And how about in Korea? Korea had only the provisions of criminal penalty against the infringement of IP rights since the enactment of Patent Act in 1946. Concurrently, U.S. does not have criminal penalty against IP infringement, and in Germany and UK, there is a criminal penalty provision. However, it has not prosecuted well. In Korea, when it comes to the intentional infringement of IP rights, the enhanced damage were first introduced in 2019 for the patent infringement and trademark secret first, and then next year adopted for infringement of trademark and design. Next, please. So, what is the law? Trademark Act and Patent Act stipulates that in determining damages under paragraph 7, the following factors shall be taken into consideration. Those 8 factors are similar to real factors, like the degree of illusion to the distinctiveness or reputation of the relevant trademark, and willful or level of awareness of the risk of causing damage, and the severity of damage, economic benefit, the duration and frequency, and degree of efforts made by infringer for remedies. But for the factor 6, fines for such infringement is a little quite controversial because we should be very careful for not getting double penalty. But if some infringers were fined, it means that it is culpable behavior. So it is a little controversial whether it is increasing the damage or decreasing the damages. Okay, next. So what is the amendment in trademark or Patent Act in Korea for compensation for damages? Yes, according to the amendment, award of damages based on hybrid calculation. Actually, for the lost profit, if there are some unsellable number of trademark or patent practicing units over the capacity of production of trademark holder or IP holder, those kind of amount was not assessed for damage calculation because even though there were no infringement, the patent holder or trademark holder cannot produce that amount of products, right? However, according to the amendment in 2020, now it has been available for damages through reasonable royalty calculation. So the patent holder or IP holders can be protected much more now. Next, please. And about the enhancement damage, there were amendments for Patent Act. Since August 2024, just last month, amendment to Patent Act. According to the Patent Act amendment, the damages for intentional infringement of patent shall be enhanced up to 5 times of the amount recognized as loss, right? Much enhanced. But for trademark infringement, not yet. Okay, thank you. Next, please. Okay, let me hit this last issue. Award of damages for products sold abroad. This patent case that I want to introduce. Okay, in Western Gecko case, Supreme Court of the United States held that lost profit from damages involving foregone overseas contract could be collected for infringement. It means that even though it's the extraterritoriality issues, but the Supreme Court held that like that. The court concluded that such damages are not subject to the presumption of extraterritoriality because Article 271F targets domestic conduct and damages statutes, and Article 284 is supposed to provide true compensation. After that, some district courts extended the ruling to the direct infringement. Next, please. Similar to U.S. Western Gecko case, there are some Korean cases about award of damages for products sold abroad. There's also patent case. The defendant produced the infringing pharmaceutical drugs in Korea, where the plaintiff's patent was best. Afterwards, the defendant made a profit by selling the infringing product in Germany and Spain, not in Korea, where the plaintiff's European outer patent was already expired. In this case, the court held that the damages eligible for compensation are not limited to damages that occurred within the country, because there is an infringement of patent by making that product
Thank you. So the last topic I wanted to address here is another crucial issue for post-judgment enforcement, and that is the process for plaintiffs of trying to enforce any order or judgment obtained against infringers in other jurisdictions. We've heard a little bit about extraterritoriality or territoriality of rights already. And so we know that because of the increased anonymity of infringers nowadays in online interactions and on the e-marketplace, infringers are really difficult to identify, and even if they are found, it is challenging for right holders to obtain judgments against these entities and actually enforce them. Also, obtaining a judgment is only the first step. Then, of course, the question is, will there be any enforcement of them, and where is that infringer located? So, according to private international law, there's always the option to sue, of course, at the seat of the defendant, but that might be difficult for a plaintiff if the location of the defendant is remote or the plaintiff has no connection in that territory, which increases the cost and time investment. There are alternative venues, such as the location of the infringement or the seat of the plaintiff, but that raises exactly the problem. Obtaining a judgment at those alternative venues means that you have a judgment in hand, but the defendant is nowhere around, which means you have to go and try to achieve the enforcement of that judgment at the seat of the defendant. Why? Obviously, the follow the money approach, right? Coercive measures are only going to be successful where the infringer is located and has assets. So we found, or it's known, that legislation and procedure for the recognition and enforcement of judgments is often complex and varies very significantly from country to country and even within states. So some of these proceedings, they can require full new trials in some countries with evidentiary procedures, with discovery procedures, etc. In some cases, the courts will examine in detail the rules and procedures of the original court, of the original proceedings, will review the legal principles, the compatibility of these principles with local principles, and all sorts of other factors to determine whether they will actually recognize the judgment in their jurisdiction. Like, there's a whole list of, for example, Canada has a whole list of factors that they check: the clarity and scope of a foreign injunctive order, the limits on the scope, the impact on third parties, unforeseen obligations for the Canadian litigant, whether enforcement would be the least burdensome remedy for the Canadian justice system, etc., etc. So that essentially means that these proceedings to have a judgment recognized and enforced can be lengthy, expensive, and also delay the enforcement for the plaintiff. In comes the Hague Convention for the Recognition of Enforcement of Judgments. Based on that situation of the difficulty to, as they say, circulate judgments, the Hague Conference on Private International Law, HCCH, drafted a treaty to facilitate this cross-border enforcement of judgments. The objective of this treaty was exactly, it aims to facilitate cross-border enforcement, reduce costs, save time for individuals and businesses involved in international disputes, and enhance legal certainty. So, a quote from the convention: the declared objective of this convention was to facilitate rule-based multilateral trade and investment and mobility through judicial cooperation, and to facilitate the effective recognition and enforcement of such judgments. So the inclusion of IP judgments was controversially discussed over months and years, mostly because of a perceived clash of principles of territoriality of IP rights with this form of sort of importing a judgment into your jurisdiction. There was a misconception that enforcing foreign IP judgments would somehow create rights in the enforcing countries or clash with conflicting rights there. With the proposed safeguards, however, we did not think that that was the case. So here's a small example to clarify what that meant. A US right holder, for example, could hold trademark rights in France, and these trademark rights in France were infringed by a Thai, an infringer who is located in Thailand. The infringement, though, is in France. So the right holder then sues the infringer in France, so at the location of the violation, and obtains an incontestable judgment. The right holder can then take that judgment and request the Thai court to enforce the French judgment by applying coercive measures to ensure that the infringer in Thailand complies with the injunction and ceases infringement of the trademark in France. A little complicated, but so the Thai court will only apply the Thai rules in Thailand to determine which court is responsible, whether the judgment meets the minimum standards, and what type of coercive measures may be applied. But in effect, the Thai court will only force the Thai infringer to comply with the French judgment in France. There is no transfer of rights into Thailand or anything like that. So in that sense, territoriality is respected, but it's of course much easier for the right holder then to enforce their judgment in Thailand. So we adopted at the time a board resolution. I'm not going to read this all, but we supported the inclusion of IP judgments under the Hague Judgments Convention, because in our opinion that would facilitate the enforcement, the following of the money for right holders across borders. Obviously, that final convention, in our opinion, had to contain provisions ensuring the maintenance, protection, and respect of the sovereignty of the ruling courts and the principle of territoriality of trademark rights. Ultimately, IP judgments were excluded from the convention, which in our opinion is a missed opportunity for right holders. And at this point, it's unclear whether there might be a reopening of the discussions to include IP judgments, but in our opinion, that could be a good option to move ahead and address the increasingly borderless infringement situation.
So as Iris was mentioning, so if, for example, if there is a foreign company which is being sued before your court and you are awarding damages, how does the Indian plaintiff go and enforce that award? Or in the reverse, if there is a Chinese company which is being awarded injunction and damages in Chinese court, how will they enforce that against an Indian company in India? So the enforceability of foreign orders or awards are directly from our CPC. There are not too many deep jurisprudence around that. But simply said, it's section 13, 14 and 44A which deal with it. And then there are certain exceptions when such foreign awards or orders will not be enforced. That's more important actually for us to understand, because 13 clearly says what kind of foreign awards or foreign orders will not be enforced in India. One, if it is not granted on merits, or two, that it was not of competent jurisdiction, or that it was incorrectly perceived in terms of international law, or if it refuses Indian law to be recognized properly, or in the case of what we saw in the earlier slides of InterDigital versus Xiaomi, if the other party goes behind the back and obtains an order without this party's knowledge, then it is absolute fraud, so it will not be enforced in India. And last but not the least, it is found to be breach of any of the Indian laws as well. In 14, it talks about the positive part. If 13 is inapplicable, which means that 13 is exclusion. So if 13 is inapplicable, then if it's a proper order obtained, then under section 14 of CPC, a certified copy of that court has to be brought into the District Court of India. And then that judgment pronounced by that court will be executed by the District Court as though it is passed by one of the Indian courts. And last but not the least, the executing court has to be filed in the District Court. I mean, if it is an original court, then it comes like those 5 or 6 high courts in India which have those original jurisdictions. Otherwise, it's always filed in the District Court and has to be executed as though it is a decree passed by an Indian court by the reciprocating territory. And as I said, we'll have to ensure the order has to be a certified copy. It can't be any other copy. It has to be an original, and it would be executed in that form. In India, one of the enforceabilities of foreign award, foreign order went all the way up till the apex court, and then it was challenged if it is enforceable or not, and then the apex court has laid down those interpretations of section 13, 14 and 44A and said that it has to be, if threshold under section 13 is met, then foreign judgment has to be executed under the 44A. So that's one of the, though it is about 13 years old, that was one of the lasting jurisprudence by the apex court on enforceability of foreign awards. Over to you, Judge Kim.
Thank you, Mr. Bharat. I think we are running out of time, so I do my best. Okay, for this issue, I focused on Korean practice about enforcement issues. Okay. What is the Korea's movement toward international institution and treaties? Korea, yes, especially the South Korea, has become the member state of HCCH in 1997. Also joined the New York Convention, the Convention on the Recognition and Enforcement of Foreign Arbitral Orders in 1973. Korea is also participating in the ongoing negotiations on the provisions of Convention on the Hague Judgment Convention, which Ms. Iris mentioned. But Korea did not sign the convention yet. Next, please. Then, how the foreign judgment is recognized and enforced in Korea. There are requirements for recognition and enforcement of foreign judgment, and which was stipulated in Civil Procedure Act and Civil Execution Act. Yes. Next, please. Civil Procedure Act and Civil Execution Act stipulates the elements or requirements. So there are Supreme Court decisions, the final and conclusive judgment, which could be recognized and enforced. Yeah, it's similar to Indian practice, I think. The final and conclusive judgment means a judgment of final trial conducted by a foreign judicial body with jurisdiction based on its authority in a procedure that guarantees mutual interrogation of conflicting parties. So this is very important element. There should be fair procedure in the foreign court and a judgment that includes content suitable for compulsory execution, such as implementation of specific benefits. Next, please. So in sum, in Korea, requirements for recognition and enforcement of foreign judgment under Korean Act are as follows. First, there should be appropriate jurisdiction that should guarantee fair procedure and that should not undermine sound moral or other social rules of Korea. And we should think about the principle of reciprocity. And among them, the second one is very important. Next, please. Okay, I brought two cases, even though these are not IP cases. There was an application for enforcement of judgment, but it was denied because the judgment was held through a simple procedure that was based only on the documents and evidence submitted by the plaintiff and was confirmed when there is no objection from the defendant. And the defendant's involvement was excluded from the proceedings up to the ruling. So the court held that in this litigation procedure, there is no mutual interrogation of conflicting parts. Next, please. But there's another case, Busan High Court in Korea. Court decision, yes. There was judgment by Superior Court of California, County of Orange in the United States. That was divorce settlement with a marital settlement agreement saying the defendant will pay the plaintiff $3,000 per month starting from January 2017. And application for enforcement of judgment was filed, and it was granted because this judgment was made by the judge based on the affidavit under U.S. Family Code. Under the above code, a judge may, in certain cases, in certain circumstances, request the submission of additional evidence or require the parties to appear in court. And in reality, even if the above ruling was made without hearing, it corresponds to a trial procedure, which guarantees the opportunity to interrogate the opposing parties based on his authority. So the procedure itself guarantees those kind of interrogation. It's very important. So it was granted. Next, please. Okay, so that is my personal opinion. Yes, as Ms. Ayers mentioned, the IP judgment was excluded from Hague Judgment Convention. So I feel sorry about that. If IP judgment would also be included in the Hague Judgment Convention, it would definitely save high cost and lengthy time for protecting IP rights in the world. And it may provide fair and effective, efficient environments, not only for the IP holders, but also for the implementer. So I think we need to keep negotiating about including the IP judgments in the convention. And more countries, including India and Korea, should possibly consider signing and ratifying the convention to increase the effectiveness of the treaty. That's my personal opinion. So let's proceed together. Thank you.
Thank you, sir. I now request the Honorable Chair to please deliver the closing remarks.
Thank all the resource persons for enlightening us in the subject of injunction and compensation in this field. And we hope that information and knowledge will help us to deal with the issue if any comes before us in future. Thank you very much.
Thank you, my lord. With this, we come to the end of technical session 3. I invite all the participants and dignitaries for lunch. We shall meet again for the next session at sharp 2:15 p.m. Thank you.
Good afternoon, everyone. May I request all of you to please adorn your seats, please? आप सभी से अनुरोध है, कृपया अपना स्थान ग्रहण करें। Now I request officers of the registry to kindly escort dignitaries to the dais, please. With the permission of dais, may I commence the proceedings? Thank you, sir. Good evening. Welcome to the fourth technical session on intellectual property and technology, what lies ahead. It is with profound honor that we gather today under the edges of some of the most distinguished legal minds and intellectual thought leaders in the world of intellectual property law and technology. This session shall be gracefully chaired by the esteemed Honorable Shri Justice Vishal Mishra, and the session shall be co-chaired by Honorable Shri Justice Dwarikadish Bansal, Honorable Shri Justice Dupala Venkatramana, Honorable Shri Justice Achal Kumar Paliwal, Honorable Shri Justice Vivek Jain, and Honorable Shri Justice Gajendra Singh. This session shall be moderated by Honorable Shri Justice Vishal Dhagat. We have amongst us an illustrious panel featuring Honorable Shri Justice Sanjeev Sachdeva, Administrative Judge, High Court of Madhya Pradesh, and Ms. V.G. Malkhani from Hindustan Unilever. Joining us in person, we are also blessed with the presence of Professor Megan Carpenter, Dean Franklin Pierce School of Law, UNH, and Lord Justice Colin Burse, Court of Appeal, England and Wales, joining us virtually. To inaugurate this session, we shall begin by felicitating our distinguished guest. For this, firstly, I request Shri B.P. Sharma, Principal District and Sessions Judge Indore, to graciously extend a cordial welcome to Honorable Shri Justice Sanjeev Sachdeva. Thank you, sir. Following that, I request Shri Hemant Joshi, Special Judge Sihor, to warmly welcome Honorable Chief Justice Vishal Mishra to this esteemed gathering. Thank you, sir. Now I request Shri Padmesh Shah, Additional Director, Madhya Pradesh State Judicial Academy, to kindly extend a heartfelt welcome to Honorable Chief Justice Vishal Bhagat. Thank you, sir. At this moment, I invite Shri Deepak Bansal, Registrar Administration, to graciously extend a warm welcome to Honorable Chief Justice Dwarikadesh Bansal. Thank you, sir. May I now call upon Shri Jayant Sharma, Registrar, Inspection and Litigation, to extend a warm welcome to Honorable Chief Justice Dupala Venkatramana. Thank you, sir. I respectfully request Shri Samresh Singh, Registrar Information and Technology, to extend a gracious welcome to Honorable Chief Justice Achal Kumar Paliwal. Thank you, sir. At this moment, may I request Dr. Dharmendra Kumar Tada, Faculty Member, Madhya Pradesh State Judicial Academy, to extend warm greetings to Honorable Chief Justice Vivek Jain. Thank you, sir. It is my pleasure to request Shri Tajinder Singh Ajmani, District and Additional Sessions Judge, Indore, to graciously welcome Honorable Chief Justice Gajendra Singh. Thank you, sir. Now I request Srimati Mini Gupta, Civil Judge, Senior Division, Indore, to kindly extend a heartfelt welcome to Ms. V.G. Malkhani. Thank you, ma'am. Professor Megan Carpenter and Lord Justice Colin Burrs has joined us virtually. I cordially welcome them in the August gathering. Welcome, ma'am. Welcome, sir. I hope we are audible, sir and ma'am. Professor.
It's such an honor to be here.
Okay. Lord.
For me as well. Very much. Thank you.
Welcome, sir and ma'am. Before we move on to the eagerly anticipated segment, let me take a moment to share a brief introduction of our learned resource persons. Honorable Chief Justice Sanjeev Sachdeva, the visionary behind this remarkable colloquium, has meticulously overseen every intricate detail of this program with unwavering dedication and precision. My Lord's profound contributions to this event and to the legal fraternity at large speaks volumes of his illustrious stature, therefore requires no formal introduction at this event. We are graced with the presence of Ms. V.G. Malkhani, representing Hindustan Unilever, a stalwart in the corporate world, who will enlighten us on the intersections of business, innovation, and intellectual property. We also welcome Professor Megan Carpenter, Dean of the University of New Hampshire Franklin Pierce School of Law, whose transformative leadership and influence in the legal education have been held globally. Professor Carpenter is a transformational leader and has recently been named one of the most influential people in legal education by National Jurist. She has over 2 decades of experience as a globally recognized leader in intellectual property and emerging technologies. She regularly speaks and writes on the topic related to IP, technology, and the legal education. A prolific author, her works includes the book Evolving Economies, the Role of Law in Entrepreneurship and Innovation. Her contributions extend to multiple book chapters and published works in prestigious journals such as Hastings Law Journal, Fordham Law Reviews, Columbia Journal of Law, Vanderbilt Journal of Entertainment and Technology Law, and the Yale Journal on Human Rights and Development. Additionally, writings have appeared in popular media outlets like New York Times, NPR, IAM, Chicago Tribune, and Smithsonian Magazine. Dean Carpenter is also a global strategist, having developed partnerships and programs across 6 continents. Her vision of IP and technology seamlessly integrate the spirit of innovation with the legal construct. Welcome you, ma'am. Our next luminary, Lord Justice Colin Burse of the Court of Appeal of England and Wales, brings unparalleled expertise, particularly in the domain of patent law. His role on the Deputy Head of Civil Justice reflects his deep commitment to advancing intellectual property rights. His Lordship's leadership in the patent court mirrors the judicial conscience that shapes our legal interpretations in ever-evolving technological landscapes. Now, I hand over.
Before we proceed further, I would like to formally welcome Lord Justice Burse. Lord Justice Burse is one of the senior judges in the Court of Appeal in England and Wales. He's also an independent judicial member of EBO. EPO Board of Appeals Committee and serves as the advisory board of judges for the WIPO Judicial Institute. I'm Justice Sachdeva, Lord Justice Burse. And it's an honor that you could join us today for this conference. Thank you very much.
Thank you. Can I say it is a real pleasure and an honor to be here, but the sound is really hard to understand. I'm so sorry. It's very fuzzy.
I'm experiencing the same thing. It is difficult to understand what people are saying. If there's a way to
Ms. Carpenter,
would be really helpful.
Ms. Carpenter, you're also having some difficulty hearing us? We'll just try and rectify that. Is it better? Are we audible to you now? That's technology. Is it any better now?
Perhaps. Let's go ahead and proceed, and then if we need clarification,
we can hear both of you loud and clear. Are we more audible now? Because we can hear you loud and clear.
I think that helps.
Or should we, or is this better?
Yes.
All right, then we'll use the handheld mic.
That's much better, actually.
Thank you. Welcome to both of you. It's an honor to have you here with us, though we would have loved it if you could have physically joined us. But we will keep that as a card for the future, that we will call upon you, both of you, to physically visit India and give us an opportunity of hosting you at a conference sometime later this year or maybe early next year. Thank you very much. And over to the chair.
Honorable Justice Sanjeev Sachdeva, Acting Chief Justice, High Court of Madhya Pradesh. Yes, sir. Honorable Justice Burse from Wales. Honorable Ms. Carpenter, our panelist. Honorable judges on the dais, brother and sister judges from the district judiciary, officers of the registry, ladies and gentlemen. As we are proceeding towards our 4th technical session, virtually the last session of this conference, in the previous 3 sessions, we have learned about what is the intellectual property rights, how they can be taken, what is the mode of filing, procedure, etc. We have learned about that in previous 3 sessions. looking to the involvement of the technology, the advancement in the artificial intelligence, as well as the globalization. The fourth session appears to be the most important session, which deals with the challenges which are required to be faced with the introduction of technology as far as intellectual property rights are concerned. Our panelists are there to address the issues. Most importantly, without the help of our moderator in this session, Justice Vishal Dhagat, the session will not proceed in the matter. So I hand over the platform to the panelist and the Justice Vishal Dhagat for doing the needful. Thank you.
A very warm good evening to all the expert panelists and all the participants present here. Today we are living in digital world and technology is emerging very fast, and every day there are new applications and softwares, and now artificial intelligence has also entered into the field. So we have designed this session. I will ask questions to expert panelists and they will answer. I have request to expert panelists that question involve technological words also, and we participants are not very expert in this technological word. So I want that you should have 2-3 sentences on this technical words, keywords in my questions. So my first question is addressed to Ms. Megan Carpenter. I want to ask, how do current AI applications challenge traditional notions of authorship and ownership in IP law? And second attached question to this is whether any specific reforms is required to address these issues.
Thank you. First of all, let me say, just give express my gratitude to the High Court at Jabalpur for having us here. I'm honored to be invited, and I wish I could be there in person and would love to do so another time. Also grateful to the International Trademark Association, INTA, for their work putting this together. Especially Gaurav Miglani, who is also an alum of our law school, UNH Franklin Pierce. And I'm grateful too to my co-panelist, Lord Justice Colin Burst, for being here with me today. You know, throughout history, every technological advancement has in some way reshaped our understanding of creativity. Whether we're thinking about the printing press or the camera that we used to take photos, now our phone, to AI, each innovation has expanded the boundaries of what's possible. What I say about emerging technologies don't need a new legal framework or perspective on, for example, the metaverse or NFTs or whatever else is coming down the pike in this hype cycle. It's important that the basic legal framework we have in intellectual property answers our questions mostly just fine. And in some ways that's true here, but in other ways, artificial intelligence is challenging some very fundamental concepts that are inherent to intellectual property. And so in my remarks, as I think about this question, and I'm going to focus on copyright because you're asking about authorship, but the same is true for rights of publicity, trademarks, patents. Here we're asking, what is intelligence? What is authorship? What does it mean to create? And our language and our framing really matter. So with a prelude, and I'm going to cover 2 different areas of law here, but as AI tools become more sophisticated, I would say as the issues, how do we want to live our lives and how do we want to construct this new world? Do we how do we continue to incentivize human creativity, and if that is still important to us? Because how we interpret the law in this space is going to have potentially profound impacts on our behavior, including our productivity, our humanity, and that incentivization to create. So with that context, I want to go into there are two different areas of AI that are implicated here with copyright law. One is on the input side, and one is on the output side. So on the input side, large language models, LLMs, use many copyrighted works as training data. So essentially scraping the internet, including written works, musical work, images. And so a big legal question that has arisen that people are debating and that is working its way through courts around the world is whether it's fair to use copyrighted works as training data to train these models. And the argument is whether or not that's fair use. So people would say, sure, it's a copyrighted work and it's being copied, but maybe what's being used is just the data, not the expression. On the output side, the question is, can works that people create with the assistance of AI tools, are those copyrightable? Even though the human has used an AI tool to help or to generate that work. So as we bifurcate that discussion, I'm going to tackle the output side first. I'm not going to talk about all the regions around the world. I'm going to really focus around, closely on the US, but I do want to mention a few different cases in different regions to show kind of how these issues are coming up on a global scale. So in the EU, InfoPuck versus Danke. InfoPuck media monitoring, and this was a 2009 case. InfoPuck has a media monitoring and analysis business. And in that case, the CJEU held that copyright would only subsist if there's originality that's flowing from, quote, the author's own intellectual creation. And so that's sort of widely interpreted now as requiring significant involvement of human creation. Now, individual member states are going to determine whether AI meets that requirement. So Germany, for example, requires the author's own intellectual creation. France, it's not surprising, sort of focuses on kind of a personal touch or intellectual creation. In that area where moral rights in the IP space are huge. China is similar, where there's a work of intellectual creation, intellectual achievement is required. But two recent cases in China can be instructive. One is from 2019, where AI-generated text using Tencent's Dreamwriter AI software. And that court held that, that it could be copyrighted, that intellectual achievement happened in both the inputs and the prompts through the condition setting. A more recent case in 2023 in the Beijing Internet Court said that the Stable Diffusion image was also meeting those requirements by inputting the prompt texts and setting the parameters, with the results that the AI-generated image reflected a kind of personalized expression of the user. So that's sort of where it's sort of working its way through in a few different regions with different approaches. Now the US has struggled with some of these issues, and at a baseline, copyrights exist in creative works of authorship that are fixed in a tangible medium, and that vests in the author immediately upon creation. So there are two cases that I want to talk about. One exists in Thaler versus Perlmutter. So it's Stephen Thaler created it was sort of like a painting, digital work called Recent Entrance to Paradise. And he applied in 2019 for a copyright. He used an AI tool to create this particular image. And in 2019, when he applied for a copyright with the Copyright Office, he said that it was all created by AI. And then the Copyright Office rejected it. He resubmitted more recently, saying that he had human involvement because he created the prompts. But the Copyright Office said that wasn't enough, that this one wasn't complicated. Maybe there are some cases that would be complicated, but this one seemed to be wholly AI generated. Another case that has come up has been a little more controversial, and that is where the author of a comic book, the author's name is Chris Castanova, she submitted the registration for her comic book, and she used generative AI tools to create all of the images in the comic book, but she used hundreds, sometimes thousands of prompts to get exactly the images that she really wanted. And the Copyright Office said, ultimately, that the tool itself was generating the images. She was not generating the images, despite her deep involvement in that, and then rejected the copyright registration. The US Copyright Office has said that it's possible that copyright would exist in output where a human is working with a generative AI tool. But the office seems to get very hung up on the X factor, the kind of variability of a work that is created, quote unquote, with generative AI. I predict this is going to soften over time. And I make an analogy, I recently published an article that makes an analogy to some of the case law around films. So when we think about movies and copyright over movies, the copyright might exist in a director or in a producer, but if the director there's only so much control that the director has over that movie. Actors will always have a little bit of, that X factor themselves. Circumstances, lighting, there's always happenstance that kind of comes into it. So you can create the structure and the prompt, but you can't completely control that creative output of a movie. I think those are the kinds of analogies that we're going to see come up as we see an emerging acceptance of the potential for a copyright for a human, for output that involves humans working with AI tools. And so on the output side, you asked about my recommendation. And so I would say this. My recommendation from a judicial standpoint is that we understand concepts of authorship and use of AI tools just as we would other tools. Right now, for example, it's not controversial that that we can use a camera to produce an image that is copyrighted, but that tool itself is generating the image. It's not the author that's generating the image. So we need to look more at substantial human involvement to determine who's the author in this situation, and draw on some of those other forms of tools, whether it's Photoshop, whether it's cameras, whether it's the film industry as an analogy. Now, I will go into, and I know this question it's kind of a big question, so I do want to address the input side as well, which is the other prong to the question. Some countries have passed training data exception laws that, in all continents, and are kind of winding some of those back now. In the United States, we have about 30 cases, I believe, on the input side, working their way through the courts. We have seen the EU regulating in the new AI Act, In Japan, there's a copyright exception for training data. And in the US, we're seeing multiple parties get involved. The Copyright Office had a request for comments that closed last December of 2023, and it's in the process of issuing policy recommendations right now on these issues. We also have some executive and legislative starts to address the issue. And we're also seeing a third component here that's really important, and those are market solutions. I think and technology moves so much faster than law, rightfully so, that we may see some of those market solutions coming to the fore to solve some of these problems before the courts end up resolving them. So in the most recent New York Times OpenAI case, they negotiated for some time before resulting in litigation. Getty Images did too. There's starting to be some licensing opportunity in this space, and I would wonder whether there are potential licensing pool solutions like we see in the patent area. So a prediction I have is that the technology, because the technology moves so much faster than law, markets will eventually find a way. But the linchpin here is unfair use. Scholars argue sometimes that the use of copyrighted works for training data is like the Google Books case, where Google scanned essentially an entire library, and courts held that that was fair use. I question that, and I think we're starting to see some case law go in the other direction. That argument, in fact, lost some steam this month in the Second Circuit of the US. So for fair use in the US, we look at the purpose and character of the use. Is it commercial, non-commercial? Is it transformative? We look at how much was taken, how creative was the work, and then the effect on the potential market. So Google Books was held to be, it was transformative, used in a way that didn't compete. But I think that in this month, for example, we're starting to see some work in the opposite direction. So in Internet Archive versus Hachette, which is a Second Circuit case this month, the Second Circuit ruled against a long-running digital archive called the Internet Archive, which was based in San Francisco, and in March of 2020, after sort of libraries were closed during the pandemic, the Internet Archive scanned a lot of different books. They launched a program called the National Emergency Library. And the Second Circuit, just a few weeks ago, rejected the Internet Archive's argument that it was fair use to do so, and found that unpersuasive. My recommendation on the input side is I feel pretty strongly that I do not believe that categorically the use of copyrighted works for training data is fair use. I don't think it's transformative in the way that Factor 1 implicates. I don't think and I don't think we need any legislative movement or reform here. I think that the structure for fair use and the legal principles that exist right now can be applied to this situation. And that if indeed it is found to be infringing, it won't stop innovation. We don't want to stop innovation, but that markets will end up finding solutions, and that the licensing of works will make sense both for the copyright owners and get money in their pocket, maintain the incentive to create, and without stopping the kind of innovation that we want to see from these artificial intelligence tools. I recognize that was a huge answer, but I hope you'll indulge me because it's a big question. Thank you.
Yeah, thank you. Lord Justice Colin Briss, you have rich experience in artificial intelligence in UK. So I want to know from you, what specific guidelines or framework do you believe the UK should adopt to assess IP infringement by AI-generated content?
Thank you. First of all, can I join Professor Carpenter in thanking the High Court in Madhya Pradesh and INTA for inviting me. I'm very sorry that I can't come in person. I'd love to come, but it just wasn't possible, so I'm afraid we've got to do this remotely, which is never perfect, so apologies for that. And it's a real pleasure for me to be here with Chief Justice of the Court and with Professor Carpenter and to engage in this really interesting discussion. There's a lot going on in the world at the moment in this area, and I'm sure we've got some interesting things to think about. Before I focus, if I may, on the exact question you asked me, I want to say a couple of things, if I may, picking up on what Professor Carpenter was talking about, because I think it might, I hope you might find that interesting. I agree with, really, of course, with what the Professor was saying. I completely understand where she's coming from. But I thought maybe a little perspective from the United Kingdom on some of these issues might be of interest. One of the curiosities about the UK is we've never had the same philosophical view of copyright that many of our former colleagues in the European Union, who appreciate the UK is no longer a member of the European Union, often had. We have a much more utilitarian view of copyright. And that plays out in this discussion because in the 1980s, our Copyright Act, which is the 1988 Copyright Designs and Patents Act, specifically included a provision which awards copyright to computer-generated works. It awards it to the person who set up the computer to generate the work. So, in a sense, a very short answer to the question, if you focus on the United Kingdom, you might think would be that an AI-generated work in those circumstances could well be the subject of copyright in the UK because we have a specific statute which says that. Now, whether in practice that would work in every case, I'm really not sure. Apart from anything else, our copyright law, having been members of the European Union for many years, is partly harmonised with the EU, and the INFAPAC case that Professor Carpenter mentioned is still the law in the United Kingdom, although technically I think we now have the power to diverge from it. Whether we ever would, I'm not sure, but there's a lively question there. But the general principle that our law is based on is a more utilitarian way of looking at copyright, and if you start from that premise, I think there is more likelihood that AI-generated material is likely to be viewed more favourably in terms of getting copyright in it in my country than perhaps in some others. But the other interesting thing is Mr. Taylor, or Thaler, I never know quite whether he's pronounced Taylor, Thaler, Taylor, Thaler, but if you haven't had the pleasure of a case involving Mr. Taylor in your courts, I bet you do. It will happen. He's a prolific litigant internationally, not just in the US. He's been in the UK and in many other countries of the world. And for all I know, he's litigating in India. I can't tell you, but he may be. And he is someone who brings effectively test cases involving artificial intelligence in the intellectual property sphere. And I had the pleasure of sitting on an appeal from one of the cases involving Dr. Taylor in the area of patents. And his cases are challenging, as Professor Carpenter was explaining, challenging the notion of what sort of IP rights can you get when artificial intelligence has been used to create the thing you're talking about. And so the example that was given was a copyright. Was copyright on an image. The one we've had in the UK, which I know has been around the world, is patents. And what Dr. Taylor did was he got his AI machine to, I'll use inverted commas, to invent a thing. It was a packaging idea, an idea for food packaging, and he put it in a patent and applied for a patent, and he's been going around the world getting patent offices to say whether he can have a patent for that or not, and he's generally losing. I think it's right to say that he won in South Africa. I think the South African courts decided that he could have a patent for that, but everywhere else in the world, he's not been succeeding, including the UK, the European Patent Office, the US, I believe, and in other countries. And the essential problem is a problem that the way that the patent law looks at it is it says, well, who is the inventor? And it would appear that the inventor, if there is an inventor, was the machine and not the man. And the patent law assumes that inventions are made by people and not by machines. And if it was made by a machine, then you can't get a patent for it because the person applying for the patent, which is a human being, they didn't invent it because it was invented by a machine. And that's the reason that these patents are not being granted. And I'm summarising sort of case law, which there are lots of long, interesting cases, and there's lots more detail in that. But that's essentially the reason that Dr. Taylor is not succeeding. And that plays into the question that you were asking about whether there needs to be any legal reforms. Now, I'm a judge, and I know many of us in this discussion are judges, and it's none of my business whether we should change the law. That's not my job. That's the job for legislators. But I can make a guess. I think there's a possibility that somebody might think they should change the law. I really, genuinely don't have a view whether they should. That's not my issue. But I can imagine that there might be some lobbying, some pressure to say that certain AI-generated material ought to be able to be the subject of IP rights, and that legislation may have to be changed if the current laws don't allow for it. I think that's something that might happen. Whether it does happen, of course, is a matter for us as individual countries to do what we think is right with our laws. But that's a prediction. Now, you asked me about infringement. And very much picking up the theme that Professor Carpenter was talking about, my view on infringement when you're thinking about the effect of artificial intelligence is that the law is actually doing okay. We don't really need to do anything other than apply our existing laws and to these new situations. If you just take an example, imagine a photograph or a piece of music or something which has been generated by artificial intelligence. The question would be, does that infringe somebody's intellectual property rights, say copyright, in a previous song or a previous image or whatever? Well, the way the law works, and I'm speaking generally, as far as I know, in terms of copyright infringement, the approach to infringement is much the same in the US, in the UK, most countries of the world. I can't, again, I'm not going to tell you what your law is. I have a feeling India's law is much the same, but that's not my business. But the way the law works in these contexts is really this. You start by asking whether the alleged infringement is sufficiently similar. Is it close enough to be an infringement? And you can dig into the detail of that. But basically the question is it similar? Is it sufficiently similar? And if it's not similar enough, it's not an infringement, and if it is similar, substantially similar, then it may be. And that's the first question you ask, and that question works perfectly well with an artificially intelligence generated material. And the next question is, can you show that the person you're accusing of infringement, the defendant, had access to your copyright work when they produced the thing that you're complaining about? Did they have access? Because certainly for copyright, you need to have some kind of chain linking the original work with the copy. Because in copyright, independent derivation, an independently created thing is not an infringement, because that's completely independent of the original work. So if you can prove similarity and you prove proof of access, then generally what the courts will do is say, though the legal burden of proof is always on the claimant, the plaintiff, a defendant who is in a situation in which they have something which is sufficiently similar and there's proof that they had access to the original, has an evidential burden in court. They have to prove, can produce some sort of evidence if they want to say it was independent, despite the fact that it looks the same and that they had access to the original. And sometimes defendants succeed in doing that. They can do that sometimes, and there are plenty of cases in which that happens. But of course, generally it's difficult to prove because they didn't do it independently. They did actually copy. Now, everything I've said to you, it applies in copyright cases for the last 150 years, and it applies just as much in artificial intelligence. There's nothing about AI which makes that different, and that analysis works, whether it was a generative AI generated thing or anything else. And the critical extra piece is that although in the area of law that we were discussing a moment ago about ownership and creation, the law seems to assume the existence of the requirement for the existence of human beings in this process. As far as I'm aware, the law has never assumed that human beings have to be involved when you're talking about infringement. No one has ever gone down that road and said, well, it's only an infringement if it was a human being who copied your work. That's just not something anyone has ever done, and I don't believe they ever will. And so, for that reason, as to try and illustrate the point, it seems to me that, and certainly in my experience of dealing with AI and IP law, that side of IP law is not going to be affected to a significant extent by artificial intelligence. What, as judges, we do have to face up to is how do we find out about how these drafted systems work? Because it's complicated. And it's a real problem. I think the biggest problem, from my perspective as a judge working in this area, is no one's very sure how much of this operates. And when you ask a question in court, you get blank looks from the lawyers. They don't even know, and they can't explain what's actually going on. And that, to me, is the biggest challenge that I feel we have in our courts, is information, is how do we get information about what is actually happening and how these things actually work in order to answer the questions. Now, the short answer is the parties should tell us, and that's how courts work. But it doesn't always quite as simple as that, because they often don't know themselves. And I think that's the challenge to me that I'm most interested in and concerned about. And I'd be very interested to know how you're doing with these sort of challenges in India. Thank you.
Thank you. Thank you, Lord Justice. Justice Sanjeev Sachdevaji is pioneer in running digital courts in India, and he is doing it from last 2 decades. So I want to know from him what specific legal principles are applied by Indian courts to determine liability for IP infringement by e-commerce platforms, and how do these differ from international standards?
Thank you, Justice Sagat. Before I come to that, I would like to add on to what Ms. Carpenter and Lord Justice Bose mentioned. There are, since you mentioned about certain challenges which are being thrown up, Justice Bose, a couple of thoughts came to my mind. In my earlier presentation, earlier part of the day, I talked about a neural link which Elon Musk has developed, which is implanted in the brain by which you can, with your thoughts, control a computer. It's at the moment at a very basic stage. Now, a thought crossed my mind, and I posed that question to the audience here, that what if such an implant was there, and with your thought, you could control a computer, and you think of an image, and then that computer prints that image. Now, normally in a real world, we will think an image and then translate onto a paper, and it would come very different from what we've thought about. But in a digital world, it might generate exactly as what you're thinking. And similarly, Ms. Carpenter mentioned about cameras using AI. Now, a photograph taken by one individual of the same landscape and by another differs because of the camera settings that those individuals do. It's the lighting, it's the position. Now, and similarly, song recordings today, there are songs where the instruments use AI to enhance some frequencies and subdue some frequencies. So question would arise as to what is the contribution of the human element, human brain in that, and what is the contribution in AI? And would these things be actually protected in our world today? Would we be able to recognize a copyright, or will we say that it's purely AI generated? So we may not be able to, it may virtually not be possible to discern as to what is the percentage of contribution by a human element and by what is the contribution by an AI. You're right, these are challenges which are being thrown, and we as judges are faced with these questions, and sometimes we don't know the answers yet because technology is emerging so fast. But anyways, those are things we'll face them when we will deal with them when we're faced with such challenges. But coming back to e-commerce platform, in India, we use e-commerce platforms substantially. And lockdown was a time when everybody migrated on from a physical shop to a e-commerce platform. And this is for all our audience. The audience, I'll tell you, it comprises of over 100 judges from the district courts in Madhya Pradesh and about 25 judges from the High Court who are physically present in the conference at the moment. Now, these social media platforms play a very pivotal role in conduct of commerce and dissemination of information. Now, for example, Amazon, Flipkart, they display so many products, and some of us have felt that we order a product and you realize that it's actually not a genuine product and a counterfeit. So question is, what is the role and responsibility of an e-commerce platform? And how do we in India sort of ensure that A, the consumers are protected, and B, the intermediaries who have no real control on what is being offered are put to task? Because what happens is they merely provide a platform where there is one seller and one buyer, and they enter into a transaction over the platform. Now these intermediaries do not stock goods. If you look at, for example, Amazon, you will find some are Amazon branded products and some are products which come in from third parties completely. For Amazon branded products, of course, since they are certifying, they're putting their label on it, they have to ensure that it is of a particular quality. But if it is a third-party product, we don't know where that product is being sourced from, actually who the seller is. I remember during lockdown, I ordered a product, and there was recently a ban on imports from China. And there was this website, I think Wish. There used to be a Wish website, and I had ordered something, and suddenly during that period something happened and there was a ban imposed on import from China. I thought maybe that product will never reach me. But it did reach me. And I was surprised. I said, if there's a ban in this product coming, how did it come? Then I looked at the packaging, and it said country of origin somewhere in Korea, and country of the seller was based somewhere in South Africa. In fact, it had come from China and it was a Chinese product. But they displayed it separately, they displayed a different origin, displayed a different manufacturer, and it came. So what is the role and responsibility of intermediary? How do you capture it, and how do you ensure? Supposing you get a counterfeit product, who do you sue? Can you sue the intermediary? Well, there is a safe harbor principle in section 79 of the Information Technology Act, which exempts liability of any intermediary from any third-party content made available on its website. But there are again some safeguards to that also. They don't have an absolute immunity. For example, they have to function, they must limit providing access to a communication system over which information is made available. Intermediary must not initiate the transmission. If the transmission has initiated from the intermediary, they'll still be liable. They should not be able to select the receiver of the transmission and select or modify the information contained. Supposing somebody has placed in information on the website, the intermediary, if the intermediary is altering the information placed on the website, then they become responsible. If they're simply providing a platform, it's, for example, a platform provided where a seller and buyer can come and enter into a transaction without the intermediary playing any role, then they are covered by the safe harbor principle. But they have to observe due diligence. and they must not have conspired, abetted, or aided or induced in the commission of the act. But one thing is there more, that in case they get to know or receive an actual knowledge or are notified by a government agency or any authority, then they must immediately remove that article. If they continue with that article on the website after having been informed that this is a counterfeit product, then they can't claim the benefit of the safe harbor principle. Now, question involved is what do you mean by actual knowledge? In 2011, the rules were that if you receive a complaint, if supposing the person who's the original proprietor of a product sends an email or a letter to somebody, to the intermediary, and says, look, this is my product and somebody is violating my copyright or trademark, that is sufficient information, sufficient knowledge for them to act upon. But then situations also arose that supposing somebody says that so-and-so's product is counterfeit or there is a trademark violation. But in fact, that's a debatable issue. If it's a pure and simple piracy, of course, there's no questions about it. But if it is something where there could be a litigation on whether it is protectable or not. So if the intermediary were to act simply on an email and take down the product, then it would become very difficult, because ultimately then it's mere letter and the intermediary takes somebody's product off the shelf. So in that case, the Supreme Court in Shreya Singhal versus Union of India delivered a judgment saying that intermediaries are bound to act when they receive information either by way of a court order or from a government agency, not information from a private entity. If it's a mere simple information from a competitor, then everybody would start writing letters to, say, Amazon and Flipkart, look, these products are counterfeit. They don't have the capacity to actually determine whether that product is violating somebody's copyright or trademark. They will simply have to then take it down. So in that concept, Supreme Court said that only if you receive information from a court order or a government agency that you will take it down. Then accordingly, the 2021 rules were amended to incorporate that principle. Similarly, there was a judgment of Amazon Seller Services versus Amway India, where Division Bench of the High Court in Delhi held that e-commerce platforms function as intermediaries under IT Act, and they are entitled to protection under safe harbor provisions of Section 79. And their involvement in services such as fulfillment, storage, or payment facility being provided does not take them out of the protection of safe harbor. And then came the judgment in MySpace versus Supercassette, which placed a timeline of 36 hours in taking down a product on receipt of an information. Over to you, Justice Bhagat.
Thank you. Over to you, Vijay Malkani. She is from Unilever Multinational Corporation, and as she is working out things practically, so I want to know from her that in dealing with online infringement, what specific proactive measures have multinational corporations implemented to protect its brands on e-commerce platform? And secondly, how effective have been these measures?
Thank you, sir. At the outset, it's a great honor to be amongst the august presence of all you erudite professionals. Thank you very much for having me here. Justice Sachdeva has already set the context for this discussion, but having said that, a brief context. As you would know, during COVID period, the e-commerce businesses got a great boom, and the online businesses or online transactions increased, and this actually led to a proliferation of online infringements, and these activities are continuing and increasing every day. That is because the internet as a medium offers a lot of protective and environment for sellers, in the sense of, like, there is great anonymity to sellers. It's not easy to find out who the seller is on an internet or an e-commerce platform. There is ease of listing. The KYC or the gatekeeping mechanism at the time of onboarding sellers is not very robust at various marketplaces. A seller can have multiple listings and he can keep coming back or switching between various e-commerce platforms, and this has been aggravated by the advent of closed groups on social media like Facebook, Instagram, etc. People can sell fakes over there, and there is convenience of using others' trademark, which actually gives rise to these infringing incidents. So if I have to give you a very simple example, like, most of us during our childhood, we would have probably played that game, whack-a-mole, You whack one, the other one pops up. So this is like that. You keep whacking and, something, they keep popping up. So it is like a parallel economy. It is not something like very easy to like get rid of them, but you can address the issue definitely. And because of the AI advancement and technological advancement, again, we found that counterfeiters are always one step ahead. It's very easy to, copy a label and put it on the internet. Say, for example, if you go into Amazon or a Flipkart, what you see is the product label. Gone are the days when it would have been fuzzy or the product description will not be very clear. Now they can generate a very clear picture of the product label of a brand owner, and you would think that it is a genuine product listing. So, it is very difficult for brand owners to catch up to that, and it puts the brand owners in an onerous situation, because you not only have to monitor the physical market, now you have to also monitor the online market continuously, and the extent of the online proliferation is so huge that it is very, very difficult for a brand owner to catch up with that. So having said that, there are definitely best practices that companies, brand owners, and definitely we do adopt to address this issue. So starting with, because of the extent of the issue, you need to invest in resources. Resources are actually, you need to have a dedicated brand protection team that not only does the surveillance on ground, but also does a 24/7 watch on the internet. And because of the extent of issue, it may not be possible for every company to have a dedicated team of resources who looks at, who crawls the web on a regular basis. Therefore, you have to invest or work closely with agencies that crawl the web 24/7, and they let you know, if they come across an infringing listing. And also because of the technological advancements, you need to invest in tools. Now, brand owners are not companies engaged in the software business, so they are not going to develop or create a tool for this. So again, you work with an agency that has a tool, that has the capability to crawl the web and, let you know about an infringing listing. And all the more important because what we see is that counterfeiters are, advancing in the way that they, work on the internet or even on the domestic platform. So they come up with labels without the brand name. So for example, if my company's brand name is Lakme, we have seen listings where you only have the trade dress, but they do not put the brand name on the label, and the brand name will be crouched in some product description or, some other description. So therefore, you need tools to be able to, catch those keywords and let us know that this is an infringing listing, and therefore invest in tools. The other thing is, like I told you, the sellers on an online platform, it offers them great anonymity. You do not know who the seller behind that listing is. You do get some descriptions, say on Amazon or a Flipkart or an e-commerce market, but you have no way of knowing if it is the actual seller who has listed the product. And therefore, it is necessary to also convert the online action into an offline action, because it's not enough if you just pull down one listing. Like Justice Sachdeva said, it's not possible to ascertain the kind of inventory that an online seller has. Therefore, you need to convert that online investigation into offline investigation and attack at the source, because you want to know who the manufacturer is. You have to take the investigation to a logical conclusion of seizing and raiding the premises and ultimately destroying the infringing goods. Most important after that is, and definitely for that, we do go to the courts once we have the results of the offline investigation, and the courts are doing a brilliant job of issuing fantastic orders, whether it's dynamic injunctions, dynamic plus injunctions. So we've been very successful in getting favorable orders from the court where they have been convinced that there is an actual instance of counterfeit or infringing activity involved online. Now, most important again is collaborative working with the marketplaces. We work very closely with each marketplace. We do capability building sessions for them, tell them how to ascertain a fake listing from our original products, so that, when they come across an infringing listing, they are able to inform us. And we do engage in mutual intelligence sharing. Of course, being very cautious about privacy regulations, unless we are going into a legal, action against the infringer. So we do tell them about the various we give them information about the various infringing sellers that we have taken action against, about the infringing sellers that we have found on other platforms, and we also get equal cooperation from the e-commerce places in terms of seller information that would be necessary for us to take legal action against them. Also, industry collaboration plays a key role. We have a group of like-minded industry professionals where we share intelligence on, the brands that are affected, the kind of actions that they are taking, the kind of remedies that they are seeking. And it's often we have found that an infringing seller doesn't only sell one infringing brand of a particular company. He will have infringing products of various other companies. So therefore, the collaboration between industry becomes all the more important, and we also do a lot of intelligence sharing and borrowing of best practices from each other. We do a lot of consumer awareness sessions because it's very important because all of us do a lot of online shopping nowadays. So not necessarily a brand-related awareness session. It's mostly a brand-agnostic awareness session, which just tells you about how do you identify an infringing listing or a counterfeit listing on an online platform. And we do this specifically for school students because we believe that they are the consumers of today and they do a lot of online shopping, and it is important that they know the difference between a fake product and an original product. We work very closely with trade bodies, and we have executed a lot of MOUs with e-commerce marketplaces to be able to get the collective to be able to have the collective strength to deal with this issue and to get the cooperation of the e-commerce places in terms of turnaround time, in terms of giving us priority when we are highlighting an infringing issue. And most important thing is advocacy. While, like I told you, the courts are doing a fantastic job, but it's also equally important to have a proper legal framework that supports your enforcement action. So we very actively advocate for effective legal framework to be in place to support the enforcement actions. We do conduct repeat surveillance to ensure that the seller has not moved from a platform where he's blacklisted to another platform, where he's listing anew. We also do repeat surveillance to ensure that he has not come back to the same listing site. And we do repeat audits against sellers to ensure that the information that he has given as part of KYC is correct. So for example, sometimes when you order goods online, you would, when you look at the retailer description, the person from whom you've received the goods, sometimes the address would be incomplete. In that instance, how do you do an investigation? So in one of our actions, what we did is we followed the courier guy to be able to ascertain, from where he is picking up the infringing product, and then we got the courier guy to let us know who the source of the infringing product is, and then we took a legal action against them through court order. So these are some of the various measures that we follow, and we've found great success in adopting them. Thank you.
Thank you. Lord Justice Colin Brice. We are running short of time, so I want to briefly know about AdWords and keywords advertising. This is new concept to all of us. So just few lines, what is it? And I want to know how have recent UK case rulings shaped the legal landscape for keywords advertising, and what implications do you see for similar cases in India?
Thank you. Yes, well, I know time is short, so I won't speak for a long time on this subject. It's an interesting question. The short answer is that these cases involve somebody else using your trademark. AdWords is an example of a situation in which it's a bit like comparative advertising. It's not the rights holder who's using their trademark, it's somebody else. And in the context of AdWords and keywords on internet searches, it's often people like Google And what we're talking about is a situation in which, for example, you type in a trademark because you're looking as a user, because you're looking for a product, say Coca-Cola, you type Coca-Cola into the internet, and what Google serves up in the sponsored links is the opportunity to buy a drink, a cola, which is not Coca-Cola. And the complaint from the rights holder is that this is infringing Coca-Cola's trademark because the user has asked for Coca-Cola and the internet has offered them something else, Pepsi-Cola or something, it doesn't matter, and that is said to be infringing. The law in the EU, including the UK, is relatively easy to state, but not easy to apply. Merely using a trademark in that way is not an infringement. The platform, Google, will not be infringing, and the person selling will not be infringing, provided the advertising is not causing confusion about the origin of the goods. Now, how you work that out in practice is not so straightforward, but in principle, it works. In other words, the law allows, in my country and in the EU, allows Adwords to use other people's trademarks. That can be done, but you have to examine whether the alternative advert that appears on the internet when you use the trademark as your search is confusing as to trade origin. So have the customers, when they click on the thing which is not Coca-Cola, have they thought that they were buying Coca-Cola when they do that? And if they did think that, then there may well be infringement. But if they understood that even though they were looking for the brand, they've then seen something different from the brand, and they think, well, that's interesting, I'll have that instead. That's not infringement. That's essentially the law in a nutshell in my country. Again, as I mentioned before, I'm not going to tell India how you should arrange your laws. That's up to you. I have a funny feeling your law is probably similar, but you will know better than me. Thank you.
Thank you. Vijay Malkani, can you discuss a notable case from Indian jurisprudence regarding keywords advertising and its implication for brand owners and advertisers? Briefly.
Yes.
Thank you.
Okay. Yeah. So just to reiterate, what Adword and keyword is that, Adword is a program run by Google. It's a paid service. And you can bid for a keyword on that paid service, which could also be a trademark of some other person. And there have been very notable cases in this regard in India. The most recent one being the Make My Trip versus Booking.com. And it's interesting to see the evolution of the judicial jurisprudence in relation to this field. Now, briefly touching upon the principle that was laid down in this, and this was a case which was recently decided by Supreme Court in March of 2024 in an appeal filed by Make My Trip. Against the Delhi High Court Division Bench's decision, which held that use of trademark as a keyword does not amount to trademark infringement. Now you would wonder, why is that? Because in a typical traditional world, if somebody is using your trademark without your authorization, it would amount to infringement. But the court has held that use of a trademark as keyword in the online advertising space does not amount to infringement, as long as it is absent from, there is no deception, there is no confusion, there is no unfair advantage or dilution of the trademark that is being used as a keyword. So this was the main principle. Now I'll quickly touch upon the questions that the courts had to consider before arriving at that conclusion. The question was, whether the use of trademark as a keyword would amount to use as a trademark under the Act. Now, typically what the court held is that you have to distinguish between use of a mark as trademark and not as a trademark. So therefore, the main function of trademark, as we know, is a source identifier. The court held that when a mark is used as a keyword, it does not function as a source identifier. For example, Make My Trip is Make My Trip and Booking.com is Booking.com. So it is distinguishing. It is not, one is not acting as a source identifier for the other. The other was whether such use of trademark as a keyword lends to confusion or deception. Again, the court held that when a person types in the keyword Make My Trip and he lands or he gets the result for Booking.com, unintentionally, he's not going to be confused by that because he knows this is Make My Trip and this is booking.com. So if I have to give you an example, in a traditional world, if you go to a modern trade, like a D-Mart or, like a shopping place, you would see that, competition products are placed side by side. You do not get confused. And also, when you say, for example, go to Apple store, you might find a hoarding for a Samsung phone. You do not get confused. It does not lead to confusion or deception. So they use the same principle to say that when you're using a trademark as keyword, it gives you a different result. It does not amount to lead to confusion. The other question that they analyzed is whether the use of trademark in this kind of advertising would amount to use of trademark in advertising under the Act. The court held that yes, it does amount to use of trademark in advertising under Section 29(6) of the Trademark Act, but it is not such a use so as to take unfair advantage of the actual owner who owns the trademark. That is because they held that, there is, again, no confusion. Of course, there is some kind of benefit that that the platform, Google platform, gets because it's a paid service. Every time somebody clicks on the sponsored link, they get money out of it. And the advertiser who is bidding for the keyword, he also gets benefited because their product or their brand becomes visible and their product comes up at the sponsored link. However, what the court held is that it is just to discern the kind of, it is offering an alternate choice to consumers, because when you are looking up on the internet, say for an Apple iPhone, you also come across a sponsored link for Samsung or other mobile phones. It is giving the consumer an alternate choice to understand who are the other providers of same goods or services. So therefore, there is no unfair advantage that is derived from use of the trademark as a keyword. And also the court very importantly held that the principle of average consumer with imperfect recollection will not apply to such cases, because the consumer who goes into a search engine and searches for something knows the applicability and functionality of that search engine, and he or she may also know that every search that comes up is not relevant. So therefore you cannot apply the test equally to a use of trademark as keyword. There was also a question of whether there is initial interest confusion which would amount to trademark infringement. The court again held in negative, saying that probably there could be initial interest confusion because you are looking for Apple, you come across Samsung, but once you've seen that, there is no longer the confusion as soon as you go into the Samsung's website. So therefore the court held that again, held in negative for that question as well, and held that there is no question of infringement over there. And also another question that the court analyzed was whether Google can be entitled to safe harbor provision, because Google is the one who is offering the keywords for money. It was held that unless infringement is proved, Google can take the defense of safe harbor under Section 79 of INTA Act. And therefore, in conclusion, the court held that use of trademarks as keywords does not amount to trademark infringement as long as there is no confusion, deception, or unfair advantage. So currently, that is the position in India laid down by Supreme Court. But however, there are a few gaps in the judgment because it's analyzed according to the situation that was presented to it. So therefore, we'll have to see how this evolves in the Indian context. Thank you.
Thank you. Justice Sanjeev Sachdeva. What are the principal jurisdictional hurdles faced by Indian courts in cross-border IP disputes, and how might these challenges be mitigated through legislative reform?
Thank you, Justice Dhagat. You see, the issue arises when there is an online platform and you are entering into a transaction on that. Now, we all access websites. Now, there are some dynamic websites and there are some static websites. Now, you have information available on a website. For example, you have an information that so-and-so product is available, but to order that, you have to go somewhere else. For example, call a telephone number or something. Or if there is a website which provides you to complete a transaction on the website, the question would be, where is that transaction concluded? In Banyan Tree Holding Private Limited case, the Delhi High Court held that to establish that an entity is carrying on business at a particular place, because we have to determine jurisdiction, is whether that transaction could be completed at that place. For example, if a website is accessible from, say, Indore, but you cannot enter into a transaction on that website, it only provides you information. then it cannot be said that the territorial jurisdiction would lie with Indore. But if the website permits you to conclude a transaction, then it would be as if the seller has opened a shop in Indore and the transaction is completed. So if a concluded commercial transaction can take place at a particular place, that will be the place which has jurisdiction. And similar was held in World Wrestling Entertainment versus Reshma Collection, where the division bench of the High Court observed that a seller providing availability of transactions through a website within the territorial jurisdiction of a court is virtually the same thing as opening a shop. Then in UTV Software Communications, the court held that Indian courts have jurisdiction to act against foreign websites or entities engaged in unauthorized broadcasting that affect Indian viewers and right of Indian broadcasters. But it also recognized the concept of the dynamic injunctions that we learnt about in the last session. It is in those cases that where the ISPs are blocked. So these are several transactions and challenges which keep getting thrown up. Legislation, we are trying to come up with legislation. The courts are interpreting the existing legislation. But the manner in which the technology is growing, the legislation will still take some time, because by the time we interpret something, there is a new technology and new development in law. So over to Justice Dhagat.
Thank you, Sachdevaji. We are running short of time, therefore I am asking my last question to Megan Carpenter. This question is important because it will be using AI practically in courts and for searching and for other facilities also. So I want to know what opportunities and risks are there with use of AI tools in legal practice, and how can they be utilized in court system, and what you predict in future?
So much. When I think that even the existence of AI tools impacts the question that that commentators were just addressing regarding keywords, where many of these AI tools, whether in Amazon, for example, will be making consumer-based decisions. When a streaming service or an online provider like Amazon is recommending 3 products, then it's kind of narrowed a field. And so the keywords, I think, have the potential to take on a new function, not just in sort of a search function, but also with regard to AI as almost a consumer filtering function, which I'm wondering if that's going to change some of these legal frameworks. But specifically on the question which presents both an opportunity and a risk in the trademark space with regard to AI tools. One of the things where I'd like to center my remarks now is really in the court system, because all of the esteemed judges with us today should be aware that the use of artificial intelligence tools by lawyers in their legal practice is quickly becoming the norm. And the majority of the large firms in the United States are using generative AI already in their practice, and that number is expected to significantly increase in the coming year. 45% of these firms are using AI for legal matters to assist them in their legal work. And about 75% of lawyers say that they plan to use AI tools in their legal work within the next year. Almost all of the large firms and corporations that were part of this wide survey by the American Bar Association expect their investment in these tools to increase significantly in the next 5 years. Now, what does that mean for the court? I think first it's important to understand that the work that's being done is increasingly what I would define as legal work. It involves research and summaries and first drafts, and sometimes soon to be final drafts, letters and briefs and motions. And it's different from the kinds of templates that we were all, perhaps when we went to law school, we graduated and perhaps we worked in a space where we used particular templates or blueprints, but this is different because the AI tools are able to analyze tens of thousands of pages of documents and then perhaps summarize the most important facts or to construct an analysis. And I was talking with as an illustration, I was talking with a founder of an AI company in the medical document space who works in medical malpractice litigation. And he'll go through the tool that he has produced, goes through tens of thousands of pages of documents of medical history, and then comes up with the most important fact. And then this tool is being used by general counsel of companies, it's being used by law firms. I said, hey, isn't that legal work? And he said, no, it's just facts. But I think those of us who are engaged in the practice of law know that facts are everything, and how you prioritize them and how you structure them makes all the difference. It sounds potentially scary, but there is a huge opportunity here. First of all, when humans are working with AI tools, all of the empirical research is showing that there is increased efficiency, that it can be cheaper to get access to justice, that it's better productivity, and can even be used in court operations. On the other hand, we want to make sure that these tools address risks, and those risks can include violation of unauthorized practice of law rules and whether we need to reform those rules, both for the person and for the tool. Thinking about model rules of professional responsibility, that's something that comes up certainly in the US, and I would expect in India as well. The potential bias, the safety of the AI tools, the hallucinations, and all of that will get better over time, but there are risks that we really need to account for. My recommendation is that, and I'm currently working on a research project that argues for essentially the certification of legal AI tools. My co-author and I are, evaluating that when people are doing legal work, lawyers, paralegal, alternative legal service providers, there are all kinds of requirements. You have to pass, say, a bar exam or some kind of exam. There are ongoing educational requirements in many jurisdictions around the world. Usually you have to have a certain curriculum. And so as these tools are becoming more specialized and used in legal services, I think jurisdictions should also consider a certification that would qualify these tools and certify them for safety, accuracy, and bias. And I'm happy, if you're interested in talking about that, I'm happy to engage more on the issue. I don't want to get lost that the access to justice problem, I expect it is the same in India, but in the United States, it is significant. Pro se litigants can be very inefficient in courts, can take up a lot of extra time, and usually don't win when they're up against someone who is represented by counsel. There is a huge opportunity for AI tools to be used in legal work where it can get more access and representation to justice for people who can't afford lawyers and who need that assistance and help. But we have to do it in a safe way. I'm very curious if Lord Justice first has a different perspective on this issue.
Thank you. Thank you for all the answers. Over to the chair.
Thank you very much. I thank you for participating in this wonderful conference. My special thanks to Justice Sanjeev Sachdeva, who has a mind behind organizing this wonderful conference on the new topic, practically the advancing topic nowadays. I once again thank you, Justice Colin Briss, Ms. Carpenter, Ms. Malkhani, being the panelist in this session itself. Thank you very much.
Thank you. It's truly been an honor.
And for me, thank you very much indeed.
With the permission of dais, may I declare the conclusion of this session, sir? Thank you, sir. Here, we will have a short break of 15 minutes. However, participants are requested to remain seated, allowing us to commence the valedictory functions promptly as scheduled. Thank you, sir and ma'am. Good evening, sir and ma'am. Now I request Shri Krishnamurti Mishra, Director, Madhya Pradesh State Judicial Academy, to kindly escort the esteemed dignitaries to the dais, please. With the permission of dais, may I commence the proceedings? Thank you, sir. My Lord Shri Justice Jiten Kumar Maheshwari, Honorable Judge, Supreme Court of India. My Lord Shri Justice Suresh Kumar Keth, Honorable Chief Justice, High Court of Madhya Pradesh. My Lord Shri Justice Sanjeev Sachdeva, Honorable Administrative Judge, High Court of Madhya Pradesh. My Lord Shri Justice Vivek Rushia, Honorable Administrative Judge, High Court of Madhya Pradesh, Bench at Indore. My Lord Shri Justice Vivek Agarwal, Honorable Judge, High Court of Madhya Pradesh. Ms. Irish Gunther, Director, Brand Enforcement and Sustainability, International Trademark Association, US. Honorable Judges of High Court of Madhya Pradesh, respected resource persons, respected Registrar General, High Court of Madhya Pradesh, Learned Director, Madhya Pradesh State Judicial Academy, respected Principal District and Session Judges, distinguished participants, esteemed dignitaries present in the auditorium, members of print and electronic media, attendees joining us virtually, revered audience, a very warm good evening to everyone. Namaskar. I, Anu Singh, District and Additional Sessions Judge Devas, extend a heartfelt welcome and into this valedictory session of the Colloquium on Intellectual Property Rights for the Judges of Madhya Pradesh, hosted by Madhya Pradesh State Judicial Academy in collaboration with Intellectual Property Office, UK, and the International Trademark Association. It is indeed a privilege to be part of this significant event, which has granted us a rare and invaluable opportunity to delve into and reflect upon one of the most crucial and far-reaching subjects of 21st century, intellectual property. As we proceed, it is my distinct pleasure to begin this valedictory session with the felicitation of our distinguished guests whose presence elevates this gathering to the new heights. I humbly request Honorable Chief Justice Vishal Dhagat to kindly extend a warm welcome to our chief guest, my Lord Honorable Chief Justice Jiten Kumar Maheshwari, Judge, Supreme Court of India, by presenting a token of our respect, a memento, and a planter that is symbol of new life. Thank you very much, sir. I now request Honorable Chief Justice Vishal Mishra to extend a gracious welcome to my Lord Honorable Chief Justice Suresh Kumar Keth, Chief Justice, High Court of Madhya Pradesh, by presenting a planter, striking symbol of flourishing growth and vibrant renewal. Thank you, sir. With a step ahead, I now request Honorable Chief Justice Pranay Verma to extend a warm welcome to my Lord Honorable Chief Justice Vivek Rushia, Administrative Judge, sorry for the mistake. I apologize for the same. Moving forward, I request Honorable Chief Justice Anil Verma to extend a cordial welcome to my Lord Honorable Chief Justice Sanjeev Sachdeva, Administrative Judge. So, to extend a cordial welcome to my Lord Honorable Chief Justice Sanjeev Sachdeva, Administrative Judge, High Court of Madhya Pradesh, by offering memento and a planter that is proud of life and breath of nature. Sorry, sir. Thank you, sir. With a step ahead, I now request Honorable Chief Justice Pranay Verma to extend a warm welcome to my Lord, Honorable Chief Justice Vivek Rushia, Administrative Judge, High Court of Madhya Pradesh, by presenting a planter, a living greenery. Thank you, sir. I now request Honorable Chief Justice Maninder Singh Bhatti to extend a respectful welcome to my Lord, Honorable Chief Justice Vivek Agarwal, Judge, High Court of Madhya Pradesh, by presenting a memento and a planter, a flourishing shoot. Thank you, sir. Here, I request Honorable Chief Justice Dwarkadhish Bansal to extend a warm welcome to Ms. Irish Gunther, Director, Brand Enforcement and Sustainability, International Trademark Association, USA, by offering a planter that is a budding life. Thank you, sir. I now take the privilege to facilitate our resource persons whom we didn't have occasion to facilitate at the prior occasions. For this, I request my Lord Honorable Chief Justice Jiten Kumar Maheshwari to felicitate Ms. Shailja Arora. Thank you, sir. Here I request my Lord Honorable Chief Justice Suresh Kumar Kaith to facilitate Ms. Gillian Erland. I request the dais to facilitate Honorable Shri Yogesh Rai. Thank you, sir. Now I request the respected dais to felicitate Shri Ankit Sahani. Now I take the moment to respected dais to felicitate Ms. Irish Gunther. Here I request respected dais to felicitate Shri Gaurav Miglani. Now it is my pleasure to request respected dais to felicitate Shri Bharat MS. Sir, with this moment, I take the opportunity to request respected dais to felicitate Ms. Vizi Malkani. Thank you, sirs. I now take the privilege of inviting Honorable Shri Justice Vivek Agrawal, Judge, High Court of Madhya Pradesh, to kindly deliver the welcome address. My Lord.
Honorable Shri Justice Jitendra Kumar Maheshwari, Judge, Supreme Court of India. Honorable Shri Justice Suresh Kumar Kaith, Chief Justice, High Court of Madhya Pradesh. Honorable Shri Justice Sanjeev Sachdeva, Administrative Judge, High Court of Madhya Pradesh. Honorable Shri Justice Vivek Rusia, Administrative Judge, High Court of Madhya Pradesh, Bench at Indore. Respected Ms. Iris Gunthar, Director, Brand Enforcement and Sustainability, International Trademark Association, USA. My esteemed sister and brother judges, High Court of Madhya Pradesh, Registrar General and officers of the Registry, Director, State Judicial Academy and officers of the Academy, our distinguished resource persons, dear participants, dignitaries present in the auditorium, members of the print and electronic media, ladies and gentlemen, a hearty good evening to everyone. It is with great pleasure that I welcome you all to the valedictory session of this enriching colloquium on intellectual property rights. I would like to extend a warm and cordial welcome to our distinguished chief guest, Honorable Shri Justice Jitendra Kumar Maheshwari, Judge, Supreme Court of India, for gracing the occasion. His Lordship has always motivated and encouraged us to deliver better and attain new heights. As Honorable Sir mentioned, and I agree in totality, our ancient system did not feel the need of patenting as we believed and practiced dharma, which was dedicated to welfare of all living beings. Thank you, sir, for gracing this event. I also welcome Honorable Shri Justice Suresh Kumar Kaith, Chief Justice, High Court of Madhya Pradesh. His Lordship has just assumed the charge of the office of the Chief Justice of the State of Madhya Pradesh. It is gratifying to note Lordship's keen insight in emerging field of intellectual property. We are thankful to the Lordship, the Honorable Chief Justice, that despite the new responsibilities, His Lordship has spared time and addressed us. I would especially like to acknowledge the efforts of Honorable Shri Justice Sanjeev Sachdeva, Administrative Judge, High Court of Madhya Pradesh, for introducing this subject in our state and offering us new perspectives. This colloquium has widened our understanding of intellectual property laws. It will not be out of place to mention that Lordship, as an advocate then, was a key player in a leading case relating to passing over conducted in this very Malwa region. A special word of welcome to our distinguished guests from abroad and also to our distinguished resource persons, namely Ms. Sarha Roberts-Fevell, Ms. Gillian Arendt, Ms. Iris Gunthar, Judge Young Kim from High Court of Korea, IP jurisdiction, Ms. Megan Carpenter, who joined us virtually, and Lord Justice Colin Birse, Judge Court of Appeal, England and Wales, who also joined us virtually, Mr. Gaurav Miglani, Mr. Bharat and Ms. Viji Malkani, who graced this occasion as resource persons, and your resources have been the source of enlightenment to this gathering. I would like to welcome my colleagues, dignitaries and participants to this valedictory session. Over the past 2 days, we have engaged in meaningful discussions, exchanged knowledge and explored the dynamic landscape of intellectual property. As we conclude, it is vital to reflect on the insights we have gathered and the significance of this field in shaping our society and economy. Intellectual property rights are more than just legal mechanisms. They are a bridge between a creator's vision and its realization, ensuring that ideas are protected and rewarded, while simultaneously encouraging the free flow of information and collaboration. This delicate balance is at the core of sustainable growth, whether it be in technology, the arts, or research. During this colloquium, we have navigated complex topics ranging from copyright and patents to trademarks and trade secrets. Our discussions have highlighted not just the legal framework, but also the ethical, social, and economic implications of IPR. The insights shared by our distinguished speakers and the active participation from all of you have made this event a resounding success. One of the key takeaways from our sessions has been the evolving nature of IPR in the digital age. With the rapid advancement of technology, we are witnessing new challenges and opportunities in protecting intellectual property, from issues related to digital piracy to the implications of artificial intelligence on creativity. It is clear that IPR landscape is in a state of constant flux. As stakeholders in this domain, we must remain vigilant and proactive in adapting to these changes to ensure that the spirit of innovation is preserved and nurtured. As we prepare for the closing remarks, I would like to express my gratitude to each of you for your active participation. The insights and diverse perspectives shared here have been invaluable, and they will continue to shape how we approach intellectual property in the future. Thank you. I welcome you all again, sir.
Thank you, my lord, for your kind words. Now I request Honorable Chief Justice Vivek Rushia, Judge, High Court of Madhya Pradesh, to kindly offer the closing statement that encapsulate 2 days of thorough deliberations.
Honorable Mr. Justice Jiten Kumar Maheshwari, Judge, Supreme Court of India. Honorable Mr. Justice Suresh Kumar Kaith, Chief Justice, High Court of Madhya Pradesh. Honorable Justice Sanjeev Sachdeva, Administrator Judge, High Court of Madhya Pradesh. Mr. Justice Vivek Agarwal, Judge, High Court of Madhya Pradesh. My all sister and brother judges. Ms. Irish Gunter, Director of Brand Enforcement and Sustainability, International Trade Marks Association, USA. Mr. Manoj Kumar Srivastava, Registrar General. Shri Krishnamurthy Mishra, Director of Madhya Pradesh State Judicial Academy. Additional Advocate General, Chairman Bar Council, President High Court Bar Association, advocates, all respected speakers present in person and virtually, judicial officers, member of electronic and print media, ladies and gentlemen. First, I would like to thank Mr. Justice Sanjeev Sachdeva for choosing Indore for this colloquium. And I hope Indore has not disappointed you. Ladies and gentlemen, as we come to the end of this insightful colloquium, I want to take a moment to reflect on the last 2 days of meaningful discussions. This event, organized by High Court of Madhya Pradesh and the State Judicial Academy in partnership with UK International Property Office and International Trademark Association, has brought together some of the best minds
in the field of intellectual property, that is IP, both from India and abroad. As we know, in the case of entertainment network versus super cassettes industry, the Supreme Court of India observed that the owner of copyright has a right akin to the right of property. Article 300A of the Constitution of India applies not only to tangible property but also to intangible properties such as intellectual properties. Over these 2 days, we explored many intellectual property rights aspects. Each session has engaging, shedding light on key issues that are shaping our present and future. I would like to take this moment to recap all our learning of the last 2 days. We begin by discussing the basic concept and the legal foundations of IPR. This set the stage for the rest of our conversation, helping us understand the core principles that make IP law strong. In the first session, we understood different types of IP rights like trademark, copyrights, design. A brief overview was given on the examination process, confusion, analysis, similarity, priority. We understood the special type of non-traditional marks, sound marks, color marks, etc. We came to know about the international treaties, including a Paris Convention and their relevance for the IP system, including India. In our second session, we talked about injunctions, damage, enforcement of the award. The insights were timely given how quickly the legal precedents are changing, how IP disputes have become more complex. In the second session, we understood the arbitrability of the dispute, a brief overview of criminal remedies in copyright and trademarks matters was given by our learned resource persons. Justice Sanjeev Sachdeva explained to us the judicial issue, including the evolution of the intellectual properties, appellate board, cancellation of process, legal and judicial issues. In third session, the discussion about the future of IP in the context of new technology was particularly thought-provoking. We looked at how the rapid advancement in the technology like artificial intelligence, blockchain, are both a tool and challenges for IPR. Important questions were raised which will shape the future of IP, and we must be prepared to deal with them. Ms. Iris Guntur has explained the position of the internet, best practice, injunction, and monetary relief, quantification of damage. Mr. M.S. Bharat has explained in the detail about the dynamic blocking injunction in the Indian cases and this field. The fourth session was very important, in which we talked about some of the challenges that lies ahead for the intellectual property. We discussed the Indian and the international case laws, the directions issue in the dispute in the digital age of artificial technology, blockchain, NFTs, electronic evidence, and the case management related to IP protection and enforcement was the key issue for discussion. Throughout these sessions, one thing remained clear: IP plays a crucial role in today's world. IP fosters innovation, creativity, which are key drives of economic growth. In India, the rise of startup is a proof of how important a strong IPR framework is. Entrepreneurs rely on these protections to innovate with confidence. One of the most important lessons from the event is the value of collaboration. IP thrives when the ideas are shared, protected, and supported. The discussions and the exchange over the past 2 days have deepened our understanding and will help us create better policies. This colloquium has been a great platform for sharing ideas and forming studies for the future of IP in India and beyond. As we leave today, I encourage you all to take insights gained here back to your work and continue advocating for the strong IP framework that fosters innovation and that drives growth. I would like to take this opportunity to thank the organizers, speakers, participants who made this event successful. Your contribution have been invaluable, and your commitment to the advancing intellectual property is commendable. I am thankful to Justice Sachdeva for selecting Indore. Let us carry forward the knowledge and the connections we have made here, continue to support the cause of intellectual property. Thank you very much.
Thank you, my lord, for motivating us all. I now invite Ms. Iris Gunther, Director of Bar Enforcement and Sustainability International Trademark Association, USA, to kindly address the gathering.
Honorable Mr. Justice Maheshwari, Judge Supreme Court of India, Honorable Mr. Justice Kate, Chief Justice High Court of Madhya Pradesh, Honorable Mr. Justice Sachdeva, Honorable Mr. Justice Rusya, Honorable Mr. Justice Agarwal, Judges of the High Court of Madhya Pradesh, esteemed judges in the audience, distinguished guests, ladies and gentlemen. As we draw this remarkable conference to a close, I stand before you with deep gratitude and great pride on behalf of the International Trademark Association. It has truly been an honor to be part of this inspiring gathering of legal minds, where we've had the privilege to delve into some of the most pressing issues in intellectual property enforcement today. First and foremost, I extend our heartfelt appreciation to Justice Sachdeva for not only giving us this invaluable opportunity to engage with the honorable judges this weekend, but also for your tremendous support in organizing this important program. We are truly grateful for the warmth of your hospitality and your dedication to making this gathering a success. We hope that today's discussions have provided all the honorable judges with meaningful insights into the critical aspects of IP enforcement and the evolving landscape of intellectual property in our modern era. INTA, since 2016, has proudly organized judicial workshops in over 15 countries, often working closely with judges from the highest courts, including regional judicial bodies like ASEAN and the Andean Community Tribunal. We are deeply honored to have become a trusted global partner in these capacitation efforts, and we always appreciate the opportunity to engage with the judiciary in shaping the future of IP protection. In addition, I have had the pleasure to host judicial panels at INTA's annual meeting for many years, and with very few exceptions, members of the honored Indian judiciary have consistently been valued speakers and participants, sharing their expertise and knowledge with their international peers. As one of the distinguished judges from my recent think tank on the judiciary of the future so wisely noted, and I quote, "We judges do not operate in a vacuum. We need to remain connected to judicial practices across borders and stay informed of key developments, especially in the absence of up-to-date laws. In such cases, it is judges who become the architects of best practices." We trust that the deliberations here have provided valuable takeaways to help you in developing these best practices in your respective jurisdictions. In closing, I want to sincerely thank each and every one of you, our esteemed participants, speakers, and organizers, the Madhya Pradesh Judicial Academy, and our colleagues from the UK IPO, for your commitment, time, and enthusiasm throughout this conference. Your active participation has made this event truly impactful. I'm confident that the ideas exchanged here will contribute significantly to the ongoing development of intellectual property laws and their effective enforcement worldwide. Let us leave here energized with renewed commitment to our shared mission of safeguarding IP rights and fostering innovation. Thank you.
Thank you, ma'am. I now humbly request Honorable Chief Justice Sanjeev Sachdeva, Administrative Judge, High Court of Madhya Pradesh, to kindly enlighten us on this occasion.
Honorable Mr. Justice Jitendra Kumar Maheshwari, Mr. Justice Suresh Kumar Kaith, my learned brother judges on the dais and off the dais. I've spoken so much, so today in the morning I was in a quandary as to what will I speak. And I spoke to one of my brother judges over breakfast. And he cited a joke, so I'm going to recite that. And I will also name the author of the joke because he said, I have copyright on this joke. So you will not recite it without acknowledging my contribution. And that, before I start, it is Justice Vivek Agarwal who cited that joke. He said Albert Einstein had back-to-back conferences to attend. And after attending several conferences in the day, in the evening, he was very tired. So last conference, he told his driver, he says, look, I am too tired, I can't go. You take my speech and go and deliver the speech. They don't know me, they will not even notice who's there. The speech is there written. He says, but what if somebody asks me a question? He said, look, I am Albert Einstein, nobody is going to ask you a question. So go. So that driver went, delivered, nobody recognized him, he went, delivered the speech, and everybody clapped. But there was one person who stood up and put a question. And now the driver, being driver of Albert Einstein, he says, look, this is such a simple question that even my driver can answer it. Go and ask him. So beginning with that, now I remember I did a case in the Delhi High Court once. I was for the defendant, and this was King International versus Sunil Agnihotri. So he had made a TV serial wherein he'd copied, there is a comic book called Phantom. So he copied the character and made a serial called Betal, because in the Hindi version of Phantom comic is also called Betal. So he was sued and we were put to notice. We had to appear in court the next day. The plaintiff's counsel was very, very clever, so he sent the BBC team to his house for an interview. So the BBC interviewed him and he was so happy, look, BBC is interviewing me. So he made a comment. He says, you know, in India, copyright means the right to copy and to copy freely. And that was the end of our case. Next morning, the judge simply cited what BBC reported and we were out of the court. Anyways, you see, it was just said that we've introduced to a new subject. This is not a new subject. This is a subject which has been there in Madhya Pradesh. We are now looking at it from a different perspective. I was just sitting here and since this thought came to my mind, I said, let me just search. You know, Madhya Pradesh has one of the highest geographical indication products, 19 in number. And there are 19 GI tags. I was just looking at some, I couldn't find all. Gond paintings of Dindori, carpet of Gwalior, batik print of Ujjain, stone craft of Bedaghat, sari of Varasoni, Sanderja mango of Rewa, and Chanderi sari are some of the few. So there are so many geographical indications, but only thing is we've not actually exploited that potential. I also just saw a report of the IP. In India, in 2018-19, there were 50,000 patent applications, which increased in 22-23 to 82,000 patent applications. Trademark registration applications from 3,23,000 have gone up to 46 lakhs. Look at the number of applications, and quite a few of them are from Madhya Pradesh. All this subject is there. We've never looked at it from this perspective. Most of us would have dealt with IPR cases, but taken them as ordinary cases. So this was an opportunity we had to sort of introduce some specialization to the subject. You all are experts. You all are dealing with these cases day in, day out. And let me tell you, the judiciary in India, especially you in the district court, handle thousands and thousands of cases. World across, in some courts, they would look at, in their entire tenure, a maximum of 1,000 or 1,500 cases in their entire tenure on the judiciary. So the exposure that you have, the potential that you have as judges, is far surpasses anywhere else in the world. So we all have the potential. The state has so much potential, so much brain. We have so many judicial officers. We are very sorry that we couldn't call all of you here. We've had about 100 plus over here from all the districts. There are several more who are watching us live. And given an opportunity, we would like to invite all of you on various subjects. I'd like to sort of end with that, to leave the chair to everybody else. Thank you very much.
Thank you, my Lord, for sharing deep knowledge and juristic view. The numerous steps taken by His Lordship for revamping technological advancements and innovative ways for justice dispensation really gives hope and promise to the system and a sense of inspiration to carry this legacy ahead. It is now my profound honor to invite our Chief Justice, my Lord Honorable Chief Justice Suresh Kumar Kaith, to illuminate us with his revered and insightful address. My Lord.
Honorable Chief Justice Jitendra Kumar Maheshwari, Judge of the Supreme Court of India, my colleague Justice Sanjeev Sudhya, whose brainchild is this function, Justice Vivek Rusia, Justice Vivek Agarwal, and all the judges, Ms. Irish Guntur, Director, Brand Enforcement and Sustainability, International Trademark Association, US, resource persons, distinguished guests, participants, ladies and gentlemen, good evening. Justice Sachdeva started his speech from joke. I also remember, and it is right time to. In Madhya Pradesh High Court, some advocates argue in Hindi. In Delhi, I allowed number of times to argue in Hindi. So one Punjabi fellow was there, Sardarji, Sikh fellow. So he said, उसने कहा कि सर मैं हिंदी गल कर सकता है? मैं बोला तुसी पंजाबी भी कर सकते हो? कहता थानू पंजाबी आंदी है? मैंने कहा मैं तो हिंदी भी नहीं आंदी. तो मेरे भाई, he said, can I argue in Hindi? I said, you can argue even in Punjabi. Then he put a question, do you know Punjabi? I said, I don't know Hindi even. As we inch closer to the conclusion of this colloquium, I have yet again the honor to address this august gathering. After almost 2 days of brainstorming, I can say that this colloquium has been successful in offering fresh insights and enrich our knowledge on this subject. Today's world thrives on innovation and creativity, hence the protection of intellectual property has never been more crucial. This maiden conference on the subject of intellectual property is also indicative of the fact that this is the future and we have to prepare ourselves to deal with the complexities which this law offers. Importance of expeditious trial cannot be emphasized enough. In addition, case laws plays an important role in shaping IP jurisdiction in our country. Hence, we must also ensure that the legal framework evolves in tandem with these developments. It is incumbent that from the time to time, we conduct a special training program for the judges of commercial courts and commercial appellate division on this subject so that there is an ease of working as well. The discussions have highlighted the significance of intellectual property law. The discussions have further encompassed the need of establishing a collaboration in IP protection. Intellectual property thrives in an environment where ideas are shared and nurtured. India's legal infrastructure must therefore focus on not only on protecting individual rights but also on fostering collaboration between industries, academia, and the government. In addition, the global nature of IP means that nations must work together to protect and promote creativity. The collaboration between the India's IP offices and international bodies like the World Intellectual Property Organization and United Kingdom Intellectual Property Office exemplifies how international cooperation can enhance domestic IP system and ensure that creators from all over the world benefit from a unified legal framework. One of our most forward-looking discussion in this colloquium has been about IA-generated work. The insights offered have made it incumbent that integration of technology into the IP framework be done because India continues to witness exponential growth in sectors like software, pharmaceuticals, and e-commerce. On a personal note, it is important to me, being head of the family, that it was a wonderful experience to listen to various experts coming from different countries at this colloquium. The exposure has been magnificent, and I'm confident that all of us are leaving this colloquium with enriched knowledge on this subject. My gratitude to the organizing committee for their painstaking efforts in not only ensuring a smooth and successful conduction of the event, but also bringing the best of resource persons from around the world. I pay my gratitude to Dr. Mohan Yadav, the Honorable Chief Minister of the State, Justice J.K. Maheshwari, Judge Supreme Court of India, Justice Satish Chandra Sharma, Judge Supreme Court of India, and each of you who participated and graced this occasion. With this word, thank you very much, and a great journey and comfortable stay in India. Thank you very much.
Thank you, my Lord, for such a captivating and inspiring address. Finally, it is my distinct privilege to invite our chief guest, Honorable Sri Justice Jitendra Kumar Maheshwari, Judge, Supreme Court of India, to impart his invaluable and profound reflections to us. My Lord.
Good afternoon, esteemed colleagues, honorable judges, distinguished guests, eminent members from the intellectual property community, judicial officers, and all ladies and gentlemen present on and off the dais. One thing is very clear. As the anchor has called finally, all right, so this last, after 2 days, I think there must be some smile after this finally word. All right, so I am here finally. Would you like to share, or would you like to sip cup of coffee? What do you want? Let us hope. Anyway, because it's a valedictory session, and in this valedictory session we have to discuss one thing. Brother Sachdeva, I note Vivek Agrawal was very serious, everything so seriously as he worked, as we would have seen. Vivek Rusia emphasizing Indore, something wrong should not happen because it is in Indore. Justice Sachdeva started with a joke. Albert Einstein. All right, I will start with a serious note of Albert Einstein. Justice Suresh Kait has said everything, whatever he should not. I will start with a serious note. Albert Einstein said, I quote, intellectual growth should commence at birth and ceases only at death. This holds true for the intellectual property regime as well as growth of innovation, which must be protected and fostered throughout its life. In this colloquium, 2 days, we have engaged in enriching discussion, exchanged valuable insights, and explored the need and complexities of the protecting innovations in our rapidly evolving world. As we conclude this event, it brings me joy and cheer we have dwelled into and discussed various facets of the IPR ecosystem. I seen in the first session on concept of legal foundation of IPR, Mr. Yogesh Pai, Sarah Robert, and Gillian Arnold aim to enhancing our understanding of intricate yet intriguing landscape of IPR. They also highlighted the significance of the international collaboration and treaties and its relevance in the context of the Indian legal framework. By these discussions, it became evident that as a custodian of the law, our role extends beyond mere interpretation, and it involves actively shaping a robust, fair, and dynamic IP landscape. When we see to the second session, the mastermind for this conference, Brother Sasteva, was there. They were focusing the challenges and best practices. Brother Justice Sasteva and Gaurav Miglani shared their respective perspective and insights broadly on 4 topics. Topic 1, jurisdictional challenges, post-abolition of intellectual property appellate board. Topic 2, strengthening judicial enforcement mechanism. Topic 3, complexities of criminal remedies in IP law. And topic 4 being arbitrability of IP dispute. Topic 4, arbitrability, is newly topic, and they have advanced that the arbitrability may be introduced. When we go to third session, it was injunctions, damages. The third session, injunctions, damages, and enforcement of awards. And in particular dealt with the emerging need of dynamic blocking injunctions, anti-suit injunctions, and anti-enforcement injunctions in management of cross-border IP disputes. I have remember one case which have come before us, Gangu Vai Kathiawadi, in the Supreme Court, asking injunction, taking several grounds, but by chance we have not agreed to grant the injunction in that case. I was a part of that case. And we see the fourth session was important on IP and technology, what lies ahead. And for lies ahead, if we see the brief points of it, then this takes away the session where ultimately even if the product or outcome is developed with the use of AI, the test of similarity remains the same. An infringement might not be necessarily committed by a human. The biggest challenge for the judges is how to get information about the working of the technology. Many of times, even the parties fail to bring that on record. The judges must prepare themselves to conversant with the evolving technology. E-commerce platform, though, are entitled to protection under IT Act, but they must adhere to due diligence to claim immunity. Also, as to the jurisdiction, it will lie where the commercial transactions could ultimately be completed. Now, where I am using this, where it lies ahead, on this, Chief Justice is here, Honorable Judges are here, Brother Sasteva is here. I am seeing the Advocate General, Additional Advocate General are here, President of the Bar Association are here, Judges are here. This conference, what I am perceiving, I find one thing is missing. Due representation of the member of the bar. I thought Brother Sasteva said, no, It is not a beginning. Madhya Pradesh has potential. Number of cases are there. Who will deal with? I talk about fraternity. And if we talk about a fraternity, then we cannot ignore the members of the bar. There should be one conference, at least on this subject, for a day in which the members of the bar must allow be participated in that conference. And in the last, as we come to the conclusion of this insightful colloquium of intellectual property right, I must express my sincere appreciation to all participants, speakers, and stakeholders who have contributed to those discussions. It has been an enriching experience to delve into the complexities of IPR, and I am confident that the insights gained here will have far-reaching implications for how we approach IP law. With this, let me leave you with the quote of Thomas Edison. It's very important. Please listen and analyze. Genius is 1% inspiration and 99% perspiration. Thank you very much, everyone. Jai Hind, Jai Bharat.
Thank you, my Lord. His Lordship's unwavering energy and dedication to the cause of justice reflects a profound compassion for the welfare of all stakeholders involved in justice dispensation system. This commitment serves as a powerful source of inspiration for us. Proceeding towards the conclusion of this enriching 2 days colloquium, I now request Shri Manoj Kumar Srivastav, Registrar General, High Court of Madhya Pradesh, to kindly propose vote of thanks.
My Lord, Honorable Chief Justice Jitendra Kumar Maheshwari, Judge, Supreme Court of India. My Lord, Honorable Chief Justice Suresh Kumar Kaith, Chief Justice, High Court of Madhya Pradesh. My Lord, Honorable Chief Justice Sanjeev Sachdeva, Administrative Judge, High Court of Madhya Pradesh. My Lord, Honorable Chief Justice Vivek Rusia, Administrative Judge, High Court of Madhya Pradesh, Bench at Indore. My Lord, Honorable Chief Justice Vivek Agarwal, Judge, High Court of Madhya Pradesh. Honorable Judges of the High Court of Madhya Pradesh, Ms. Iris Gunthur, Director, Brand Enforcement and Sustainability, International Trademark Association, USA. Esteemed resource persons, Shri Krishnamurti Mishra, Director, Madhya Pradesh State Judicial Academy, Shri B.P. Sharma, Principal District and Session Judge, Indore, Principal District Judges and Judicial Officers of the state, attending the function physically and virtually, Officers of the Registry, Madhya Pradesh State Judicial Academy and District Court Indore, members of the bar, distinguished participants, esteemed dignitaries present in the auditorium, members of the print and electronic media, virtual viewers, ladies and gentlemen. It gives me great pleasure to say a few words as we conclude this program. As we approach the final leg of this event, I am reminded of the saying, all good things must come to an end. This program has highlighted that change does not happen overnight. Various challenges faced by judges in the domain of intellectual property were taken up and thoroughly discussed by our esteemed speakers. I trust these deliberations have helped to clear many doubts and provided valuable insights to the participants, sensitizing them to the intricacies of intellectual property law. At the outset, I extend my sincere gratitude to my Lord, Honorable Chief Justice Jitendra Kumar Maheshwari, Judge, Supreme Court of India. It is always an honor to have your Lordship at events organized by the High Court. Despite your elevation to the Supreme Court, your Lordship connection with us remains strong. Your Lordship present today has truly blessed us, and we are grateful to my Lord. I express my heartfelt thanks to my Lord, Honorable Chief Justice Suresh Kumar Kaith for accepting our invitation soon after assuming the office. On behalf of the High Court and myself, I extend my deepest thanks to your Lordship. I also extend my sincere thanks to my Lord, Honorable Chief Justice Sanjeev Sachdeva, for his continuous support and invaluable guidance, which were pivotal in organizing this program. I'm extremely grateful to my Lord, Honorable Chief Justice Vivek Rusia and Honorable Chief Justice Vivek Agrawal for gracing this occasion with their presence. I thank all the Honorable Judges of the High Court for their participation, which added immense grandeur to this function. I also express my deepest thanks to the UK Intellectual Property Office and the International Trademark Association for their initiative in conducting this program. This collaboration will surely help to sensitize the judiciary of Madhya Pradesh and strengthen the adjudicatory mechanism related to intellectual property rights, violations, and protection. I extend my special thanks to the resource persons for their valuable contributions, helping us understand the nuances of intellectual property law. I'm also thankful to the principal district judges and members of the district judiciary who joined us physically and virtually. I express my wholehearted gratitude to Shri B.P. Sharma sir, Principal District Judge Indore, and his team for their unwavering support, which made this program a success. I'm deeply thankful to all the participants, including the honorable judges and members of the district judiciary present here for their full involvement throughout the program. I also thank Director, Madhya Pradesh State Judicial Academy, Shri Krishnamurti Mishra, and his team, as well as Office of the Registry for their contributions and assistance in organizing this event. I also extend my deepest gratitude to the management of Brilliant Convention Center Indore for their logistic support and hospitality. Special thanks to the staff of the High Court, Madhya Pradesh State Judicial Academy, and District Court of Indore. I also thank the IT team of the High Court of Madhya Pradesh for the tremendous efforts in webcasting this program across the state. While I am unable to thank everyone individually, I sincerely appreciate all those who contributed to the success of this event. Thank you all very much.
Thank you very much, sir. We have now reached the end of this insightful event. With the permission of dais, I declare proceedings to be closed, sir. So, to capture this moment, with the permission of dais, I request participants to come on this dais for this. I request all the participants to please refer the training order. In that order, first 33 shall come on the stage first, thereafter rest 33, and shall be followed by rest of the participants. So, I also request all the resource persons to please join us for this photograph, please. There is a bit change. We shall have the photographs in the group of 25-25. So I request only first 25 to be here, and it shall be followed by the rest 25.